Good morning and welcome to today's hearing of your Justice Commission. Today we continue the inquiry into land injustice in hearing block 6. And I'd also like to mention that Chair Burke is an apology and will be returning next week. I'd like to take the moment to acknowledge that we are on the lands of the Wurundjeri and pay respects to my elders, past and present, all those that have come before us, so that we are able here today to have voice. I would like to honour all Aboriginal people in the room and all Aboriginal people online, all their ancestors, the hard work they've done, the battles they've fought, to be able to, again, have voice and be here today. So as I always say, Wominjeka, come with purpose, and welcome to the lands of the Wurundjeri. Can I now have appearances, please, Council?
Thank you, Commissioner. My name is McAvoy. I appear with my learned junior, Mr. Tim Goodwin, as counsel assisting. We thank you for the welcome to country, and on behalf of counsel assisting, I acknowledge that we are here on the lands of the Wurundjeri people, and we acknowledge all First Peoples both here online and wherever they may be. Thank you, Commissioner.
Please, Commissioners, my name's Bennett and I appear with Ms Healy and Mr Petrie on behalf of the State of Victoria. And in so appearing, Commissioners, I'd like to pay my respects and the respects of my clients to the people, the Wurundjeri people of the Kulin Nations, to thank the Commissioner Hunter for that welcome and to express our respect to elders past and present, to extend that respect to all First Peoples present in the Commission today and watching online. I'd like to acknowledge that sovereignty has never been ceded over these lands. And I'd like to say thank you to the Commission for the opportunity to appear today. Please, the Commission.
Thank you, Commissioner. The first witness today is the Honourable Natalie Hutchins MP. It's intended that we will be finished with the Minister's evidence by approximately 3 p.m, so we will go past lunch. And I can indicate that we propose to have short breaks on the hour throughout the course of the day, subject to, of course, the Commission's approval. And I will draw the need for breaks to the Commission's attention in due course. Commissioners, I call today's first witness, the Honourable Natalie Hutchins MP, Minister for Treaty and First Peoples, and I note that the Minister is in the witness area.
Thank you. Stop.
Now, Minister, if you could just tell the Commissioners your name and position.
Yes, it's Natalie Hutchins, and I am the Minister for Treaty and First Peoples, the Minister for Jobs and Industry, and the Minister for Women in the Victorian State Government, and the member for Sydenham.
And Minister, do you undertake to provide truthful evidence to the Europe Justice Commission in your evidence today?
Yes, I do.
Now, Minister, you have provided the Commission with a statement. Do you have that statement in front of you?
I do.
That statement is dated the 18th of March 2024.
Yes.
Last page? Yes? Yes. And your signature appears on the last page.
It does.
Runs to 310 paragraphs.
Yes, it does.
And the content of that statement is true and correct to the best of your knowledge.
Yes.
Commissioners, I tender that statement and it will be given a tender number in due course.
Thank you, Mr McAvoy.
Now, Minister, I might start with some questions around your term now as a Minister for Treaty and First Peoples. This is your second time around, isn't it?
It certainly is.
And your first engagement with First Peoples from a ministerial perspective was in 2014?
Yes, it was.
And what role were you appointed to then?
I was the Minister for Aboriginal Affairs.
And When you came into that portfolio, how would you describe your level of knowledge about First Peoples in Victoria?
If I may, is it possible to do an opening statement?
My apologies.
Yeah.
My apologies. Yes, you may.
Yes, thank you. I'd like to begin by acknowledging the traditional owners of the lands on which we meet today, the Wurundjeri people, and pay my respects to their elders, past and present, and pay my respects to elders and ancestors, leaders, knowledge holders, and all of those past and present. I acknowledge traditional owners and First Peoples across the state, everyone viewing this live stream, and those who may read the transcript of this historical evidence into the future. First Peoples never ceded their sovereignty over these lands and waters. When colonisation began, there was no regret for Aboriginal people's occupation, care, or connection to country. No regard. The British Crown claimed legal sovereignty over the lands we call Victoria, even through First Peoples, even though First Peoples were here first. First Peoples in Victoria have maintained their systems of governance and law and spiritual and physical relationships to lands and waters over tens of thousands of years and continue to do so. It's an immense privilege to appear here today before the nation's first Truth-Telling Commission as Victoria's Minister for Treaty and First Peoples, and something that I dreamed of maybe 10 years ago when I first came to this portfolio. The Commission has a historic truth-telling mandate of unprecedented scope, and I thank the Commissioners for inviting me to participate in this process. Your inquiries to date have demonstrated the importance to all Victorians, including future generations, to hear the uncomfortable truths and facts about our state's history. These are truths about colonisation, dispossession, profound injustices, but also of First Peoples' extraordinary resilience, strength, advocacy, and resistance. The ancestral ties between traditional owners and the lands and waters of this state represent tens of thousands of years of continuous culture. For this entire time, First Peoples have practiced culture and care for this country. All Victorians benefit from living this wisdom. And I was appointed as the Minister for Treaty and First Peoples in October last year, having previously held the portfolio in 2014 to 2018. It's been my great privilege to see firsthand the progress that has been made during this time, building on earlier achievements such as the Aboriginal Heritage Act, the Traditional Owners Settlement Act, and the Victorian Aboriginal Affairs Framework, and the self-determination embedded in that. This progress has been led by the traditional owner groups, by Aboriginal controlled organisations and representative bodies such as First Peoples Assembly of Victoria. We're on a path towards self-determination, but we're not there yet. I understand the work we have ahead of us to build a strong public record of the facts of Victoria's history and for all Victorians to deeply appreciate the experiences of First Peoples historically and today. I'd like to acknowledge the First Peoples who have already appeared before the Commission during this hearing block, providing truthful and powerful accounts of the issues of land injustice. From these testimonies, Victorians have heard truths about colonial violence and massacres, as well as the reserve system here in Victoria. This violence was brought home in stark terms with the opening of this hearing block taking place at Convincing Ground on Gunditjmara country, the site of the state's first recorded massacre of First Peoples. Could I particularly thank Commissioner Lovett and all of the Gunditjmara traditional owners for the considerable generosity in hosting on country at a site that represents so much grief and loss. My witness statement to the Commission seeks to contribute to the historical record by outlining the state government's role in dispossession of First Peoples and their subsequent exclusion from social and economic opportunities. I'm acutely aware of my responsibility as the Minister for Treaty and First Peoples to continue to support the Commission and First Peoples Assembly to progress work of truth and treaty. I apologise for the acts of my predecessors in causing or contributing to the dispossession and exclusion of First Peoples and for the ongoing impact that this has had. My statement reaffirms the Victorian Government's commitment to self-determination. We cannot build a better future without knowing the truth about the past. The Commission's work shows us how our past continues to impact our present, and it recommends we will inform treaty negotiations when they commence later this year. Treaty is about making sure First Peoples have decision-making powers and resources for their healthcare and economic opportunities, housing, education, language, and most importantly, practice of culture now and into the future. Treaty is about opportunity to bring Victorian communities together based on understanding and, really importantly, respect. It's about coming to grips with the history we share and creating a better future together.
Thank you, Minister. You've got some water there. Thank you for that opening statement. As I perhaps prematurely was asking you a few moments ago in relation to your first stint as the Minister for, as it was then called, Aboriginal Affairs in 2014, are there observations you can make about your level of appreciation and understanding of the issues of First Peoples at that time?
Yes, certainly coming into the portfolio and not having a long history of working or any history of working in Aboriginal affairs or for any Aboriginal organisations, I felt it was important to spend some time listening, which I did. I undertook 6 weeks of visits and meetings when I first came into the portfolio to understand what the issues were facing First Peoples and to also ask what they thought were the solutions. And there was not a single conversation that didn't end with a call for treaty and truth-telling as part of those discussions over that 6 weeks. And it really, whether I was talking about closing the gap targets in health or whether I was talking about access to land by traditional owners, I felt that the conversation every single time came back to truth and treaty, and it really gave me a pathway forward as a new minister to focus in on what we really needed to do as a state to address the issues and concerns and to try and redress some of the injustices.
Can you remember some of the communities and places that you visited during that 6-week tour?
I can. I, during that time, went to Budge Bim for the first time and met with the Gudjamara. I spent quite a lot of time in Gippsland, in Moe, in Morwell, from health organisations to gathering places down to Bairnsdale, and a lot of different locations across Metro Melbourne. Regretfully, in that 6 weeks, I didn't manage to get to Robinvale or Mildura, but I did later in the year. I would have a guess at that the number of meetings in those 6 weeks probably went more than 100 meetings and conversations. I learnt pretty quickly that the way forward was to always start with a cup of tea and ask people how they are before getting into the sad business and the history, and also then discussing what solutions could be.
In that series of meetings, were there people that you met or events that you can still remember that had any profound effect on you or gave you information that has stuck with you till today?
I would say pretty much every single one of those meetings had a profound effect on me in a different way, different levels, from experiencing the anger of First Peoples, particularly in visiting Shepparton and sitting down with Yorta people, not really understanding the hurt and betrayal that had been forced on them in more recent times in their native title claim, not having an appreciation for that until I sat at the table and felt that anger over the course of a good probably 2 hours. But also Coming to the realisation also of how, during that period, how real suicide rates are in Aboriginal community. I don't think there was a single group that I met with that weren't touched by suicide in the recent years before me, having those conversations. And I have no doubt that the effects of that are still being felt today.
Looking back now, coming back to the portfolio for a second time, are there any observations you can make about your first term as minister, and any things that you may have done differently?
If I could have sped up this process to have occurred earlier, both truth-telling and the treaty process, I think I would have pushed harder on the timeframes to be now 8 years down the track, and hopefully at the negotiating table later this year for treaty. But it would have been better had we have had this sooner, had a Justice Commission sooner in this process. That would be the only thing I'd say.
From that, are we to take that you see the process of truth-telling and the findings of this commission and its recommendations as integral to the treaty process?
I would say they're a really important part of the treaty process. I'd say they're even more of an important role in terms of the ongoing historical record, and also the shaping of future governments' policies and our decision-making and policies now.
Well, in that regard, it might be a convenient time to turn to part 8 of your statement, which is paragraph 58. And I might ask the operators to bring page 58, paragraph 288 of the Minister's statement up on the screen. That part, Minister, is called My Vision for the Portfolio. I'm sure you're familiar with it. And in this part of your statement, you speak about your vision for the portfolio, and it's correct that you're expressing your views about injustice and your hopes for the treaty process. That's correct?
That's correct, yes.
I'm going to ask you to read through the paragraphs, and I'll tell you when to stop. Now, we're starting at paragraph 288, and I might have some questions for you as we go, but if you could start there, I would be grateful.
Colonisation involved taking vast lands and waters of enormous value from First Peoples. This dispossession lies at the heart of many of injustices experienced by First Peoples historically and today. Dispossession was justified through an erroneous and deep damaging ideology of racial supremacy. We must reckon with the harm that colonial violence inflicted on First Peoples, recognise the steadfast presence and persistent contributions of First Peoples in the face of it, and address the ongoing legacies that continue today. Truth-telling provides an opportunity for us to develop a shared understanding of our history and of the contemporary injustices that persist, to guide the reforms needed to address them.
Thank you. Just one moment. Now, in terms of the dispossession, the injustices wrought on First Peoples referred to in paragraph 288, with dispossession perhaps being at their heart. Do you say that there were other forces at play other than just merely taking the lands of the First Peoples? So at paragraph 288, you say, this dispossession lies at the heart of many of the injustices experienced by First Peoples historically and today. The injustices experienced today, do you say that some of them have a different origin other than dispossession?
I think what I mean is, in terms of injustices experienced, that the onflow effect of taking land and some of the dispossessions that occurred at the time, like the stopping of cultural practices and the taking of language and stopping language, and ultimately the taking of children as well. They were all connected to the taking of land. They were all the flow on from that.
Thank you. And in relation to paragraph 290, when you refer to contemporary injustices that persist, you're referring to loss of land and water and resources?
I am referring to that, but also captured within that is things like racism and systemic barriers that are still faced by
unresolved intergenerational trauma.
Yes.
Loss of self-determination.
Yes.
Loss of self-governance.
Yes.
Delayed implementation of existing commitments.
Yes.
Okay, if you could continue, please, at paragraph 291.
Victorian Government is committed to preventing the reoccurrence of past wrongs and addressing ongoing injustices through self-determination. This includes reform of existing legislation and policy, as well as negotiated change through treaty. I reiterate my commitment to implement changes to the Aboriginal Lands Act of 1970 as recommended by the 2021 review, and to change land-related restrictions to the Aboriginal Lands Act 1991 in line with community aspirations. I'll work with the Framlingham and Lake Tyers communities to continue to further reform the 1970 Act and bring Framlingham out of administration.
Please continue.
I'll also lead the government's response to the First Peoples Review and work to make sure that the compensation and rights available to traditional owners are just and fair. I look forward to continuing to work with the Aboriginal Heritage Council and other stakeholders to ensure the Aboriginal cultural heritage regime is self-determining and strong. In relation to Victoria's whole of government Victorian Aboriginal Affairs Framework, our commitments under the National Agreement on Closing the Gap, I will work across government to address the critical issues of First Peoples control and ownership of their data and measures of success. I'll also continue to ensure priorities put forward by ACOs and governance forums are heard and prioritised in Victoria and on the national stage. Keep going? Yep.
Yes.
Treaty is an agreement making to ensure First Peoples have decision-making power over their healthcare, their families' housing, their kids' education, the practice of their culture for now and into the future. The treaty process is about coming together to make a practical agreement to change what isn't working and make sure Aboriginal Victorians can make decisions about their own future. This path to self-determination offers the state a chance to build a more equitable and inclusive Victoria in which all Victorians can take pride.
Continue.
The government is mindful of the state's obligations to be ready to negotiate treaties that potentially include innovative and more equitable approaches to land and water justice, environmental management, economic and community development, cultural heritage and Indigenous data sovereignty. While the treaty framework does not place any limitations on what can be negotiated through treaty, it does specify these topics and a range of others being subject matters for negotiation. The Victorian Government must also be responsive to the decisions of the traditional owners in pursuing formal recognition and must deliver outcomes that meet traditional owner aspirations. Traditional owner treaties will provide a mechanism for traditional owner groups to form First Peoples Treaty delegations and negotiate directly with state for the recognition of inherent rights and their connection to country. Traditional owner treaties can progress land justice for traditional owners whilst also contributing to regional investment and rejuvenation. At the heart of this approach, there must be a critical focus on relationship building and collaboration or collaborative negotiation. This will enable traditional owners, the state, local governments and other stakeholders to work together towards a mutually beneficial and just future that benefits all Victorians. The state has taken significant steps to address the harm it has caused, and yet injustices persist. I acknowledge that we have yet to adequately address the prevalence of interpersonal, institutional, and structural racism, or to fully make aware for true self-determination. The government is learning from the mistakes of the past.
I might just ask you to pause there. I can tell you that the government has, through various witnesses and representatives in these hearings, accepted numerous times that institutional and structural racism against First Peoples continues to exist in this state, particularly in Victorian government agencies. How does the government propose to adequately address racism?
Right at this very moment, there is comprehensive work being done by the government on an anti-racism strategy, which is co-chaired by two MPs in Parliament. One of those is Sheena Watt, our member for the upper house in the northern suburbs, who is also working with Aboriginal community across Victoria to ensure that the racism, the daily occurrences, the systematic barriers that are there are addressed through this strategy. But aside from that strategy that is not far from being launched, there has also been a range of training that has happened across our public service, particularly in the space of truth-telling and the prospect of treaty making that we have undertaken, as well as cultural awareness training as well.
And is there monitoring which is taking place as to whether that training is effective or not?
I would say that part of the responsibility of our secretaries and deputy secretaries across our departments is to ensure that their staff are being trained in those areas.
There's no systematic monitoring of the effect of that training at this point?
Look, not to my knowledge, but there is a role for our public sector ombudsman, and there may be some roles within that that person's role.
Thank you. If you could continue on with paragraph 301.
Just in relation to the strategy that's been developed, how much funding was committed to that, to develop the actual strategy? Are you aware?
I'd have to take that on notice.
Okay.
It's sat between myself and also the multicultural minister, and I don't have a dollar figure in my mind at the moment. And I dare say that some of the resourcing that will come for that strategy will, not to preempt any future budgets, but will be in the future.
Yeah, and probably just important to note that that's not just a racism strategy about Aboriginal people experiencing racism. It's a multicultural as well.
Yes.
Yeah.
Thank you. Paragraph 301.
We're on the cusp of fuller expressions of self-determination through treaty and what I hope will be the meaningful realisation of First Peoples' self-determination, taking into account the recommendations from the York Justice Commission.
Pause. Yep. Do you have any view as to when it is likely that the first treaty might be entered in Victoria?
I think the ambitions of both the government and the First Peoples Assembly is that we are at the table negotiating by the end of this year, but it is dependent on the processes that have been outlined through our legislation and through the establishment of the Treaty Authority, and the processes that involve them inviting us, the parties, to the table when all of the requisites have been acquitted.
If, with your knowledge of the process, if a treaty negotiation process commences at the end of this year, what's the likelihood of it being concluded before the next Victorian state election in November 2026?
I'm not going to preempt how long negotiations will take, because at this stage we don't have all of the claims on the table, to be honest. That's still a process ahead of us. And I'm very confident that negotiations will be well underway. If we can reach settlement by then that would be a desire of the government to see that happen.
Thank you. Paragraph 302, please.
Treaty in Truth offers all Victorians and Aboriginal and non-Aboriginal an opportunity to shape a new relationship and a new future. This is an opportunity for a renewed state identity, an identity based on shared understanding of our history, including the systemic injustices and deliberate exclusion that prevented First Peoples from practicing culture and passing on knowledge, as well as denying First Peoples of economic, social and political opportunities that all Victorians have a right to share in. First Peoples culture is rich and strong. We all have a brighter future if we can learn from Aboriginal culture, practices and ways of working. Victoria will thrive in the future if we can come to terms with the truth of unfinished business of our past. If we come to terms with our past, we can all be a part of a better future. Treaty is a path to getting there. It is an immense privilege to be the Minister for Treaty and First Peoples at this moment in time, and I'm deeply indebted to the work of the inspirational Aboriginal leaders and community members who have brought us to this point. I want to express my sincere thanks to First Peoples communities for engaging in this process and for sharing their truths. I'm deeply humbled by the patience and dedication of Aboriginal communities in their pursuit of justice. I'm acutely conscious of the enormous responsibility on the state and myself as Minister for Treaty and First Peoples as we work to achieve truth and treaty. The state must listen to First Peoples and in turn bring the broader community along with us. As stated in the Treaty Act, future treaties should enhance the existing laws of this state and acknowledge the importance of culture, of Aboriginal identity, bring pride to all Victorians and have a positive impact for all of Victoria's society. In other words, treaty is for everyone. The process of truth-telling that this Commission has been undertaking necessarily involves the sharing of facts that many find difficult to hear. But responding to facts must involve transformative change. We cannot continue with the status quo because we know that it has produced injustice. I believe that with a collaborative approach, Victoria will be able to demonstrate the power of transformation through treaty. We have been making progress on treaty since 2016, and we remain committed to this work. In the introduction of my statement, I refer to my aims as the Minister for Treaty and First Peoples to ensure that all traditional owner groups have access to country that fulfills their rightful culture, social and economic aspirations. This is a future where traditional owners have access to land for ceremony and culture, to build housing for their people and to generate collective wealth that sustains the communities and contributes to regional economies. A future where traditional owners have truly participated and enriched the social, political and economic life of the state. The state must give due respect to First Peoples' relationships with the land, waters and resources of the state that we all share, and ensure that this relationship is protected and coexists with other types of public land use. I want to see a Victoria where First Peoples' places of historic, spiritual significance are valued by all, and First Peoples' culture, knowledge and heritage is celebrated as a foundation of our state's identity. I'm committed to working with traditional owners to ensure that First Peoples' knowledge is properly respected and valued to inform state management of lands, waters, for benefit of all. I commit to working towards a future through treaty where self-determination is not an aspiration but a reality for First Peoples, a future where First Peoples and state can come together in partnership to meet the opportunities and challenges of tomorrow. Thank you for the opportunity to speak frankly about this unique and complex portfolio, and thank you, Commissioners, for your work in ensuring that the truth of First Peoples' experiences is heard and recognised. A collective understanding of Victoria's past and present will enable us to walk together towards a better future.
Thank you, Minister.
I ask a question, please, Council? Minister, do you accept that there's a deeper level of systemic racism towards Aboriginal people than other multicultural communities, for instance? And I'm not trying to take away from the racism that multicultural communities play, but you've articulated here that we as a people have inherent rights to these lands and waters, and you've articulated there's ongoing systemic injustices towards our people. Did you see and accept that there's a difference in the level of racism that Aboriginal people face in Victoria?
Yes, I do accept that there's a different level of racism.
And that Aboriginal people shouldn't be lumped into a broader bucket of a broader point that we are different to multicultural communities. We are not a multicultural community as the First Peoples of this land. Okay, it's the point I'm making, that we are not multicultural in that context. We are traditional owners, and we have ongoing rights and connections to this country.
Yes, I acknowledge that.
Thank you.
Thank you, Commissioner. Minister, thank you for your patience in reading through the final paragraphs of your statement. I suggest to you that by that, the inclusion of those paragraphs in your statement, you are signalling to this Commission and the First Peoples of Victoria and the general public that you will be a champion for treaty.
Yes.
And that you are shouldering the burden of leading the treaty process through the government.
Yes.
So you've made many commitments. You've expressed your aims in a way that where you have not opted to say that we, the government, will do it, but you've made personal commitments. You're saying that I will do it. That's correct?
Yes, but I make those commitments knowing that I have the full support of the Premier.
Yes. Now, you agree with me that it's very important that that for such a profound change as the treaty process is bringing to this state, that it's important that the Premier of the state have a full level of commitment and leadership on the matter?
Yes, that's correct.
But that there also needs to be within government a champion that drives it through the cabinet processes and through the other agencies, and that's you, is it?
I would say that there are quite a few champions across government, and I've got quite a lot of ministerial colleagues that are very passionate about seeing treaty come to fruition. I wouldn't say I'm the lone wolf champion in this, but certainly.
I'm not suggesting, and I'm sorry for interrupting you, Minister. I'm not suggesting you're the only one that supports the treaty process, but I am suggesting that processes such as these require people to be at the leadership point within government, and that person is you.
Yes.
And
it's reflected in the title of my ministry.
That's right.
It's the first time.
It's not a secret. I mean, that's your title. Now, how important in your role is the oversight and monitoring of government performance as against the matters that are essential for the treaty process?
I'd say that's a very big focus, and something that my department in particular is extremely focused on. Yeah.
I might just ask you to turn to paragraph 158 of your statement. We could see that on the screen as well, please, operator. Now, if you could read the first sentence of that paragraph 158.
While the VGAR is an important and necessary mechanism for holding government accountable for how it's delivering on its commitments to enable First Peoples self-determination, I acknowledge that there is currently heavy reliance on department self-reporting and therefore lacks independence.
That's well, thank you. And just for those who unfamiliar with government acronyms, what does VGAR stand for?
It's the Aboriginal Victorian Aboriginal framework, which incorporates our self-determination framework.
I think you'll find that that's a different body.
Um,
This this is the Victorian Government annual report on Aboriginal people.
which is, sorry, yeah, it is linked in with the Victorian Aboriginal framework. This is the annual report that comes out.
And so in reference to that report, you say it is heavily reliant on departmental self-reporting and therefore lacks independence. And that seems to be, on its face, an acknowledgement that the agencies within government, when asked to report upon themselves, can't do so in an independent manner.
I think sometimes resources and time are a factor in that. I wouldn't say it's necessarily an unwillingness. I'd say that, there is more that can be done.
And so it's necessary to have some independence in the reporting and monitoring with respect to government performance.
Yes, I would say so, and particularly when it comes to closing the gap targets.
Mm. And why is that?
I think because with genuine self-determination commitments that the government has made, it's not just around consulting and reporting, but it's also around making sure that there's shared power, and that includes monitoring as a part of that.
Is it also the case that with government monitoring itself, the targets under the closing the gap reforms have dismally failed?
That could be a big contributing factor, yes.
Minister, can I just ask you, within this hearing block and the hearing block before that we had last year, we've heard repeatedly, well, there's been a plethora of strategies and frameworks that we've heard about, mostly with nice Aboriginal names.
Yep.
We've heard about 11 of them, I think, on Monday or Tuesday. I've got a few questions. So with all of those, not a single one, to my recollection, was actually delivering fully on its commitments. Nearly all of them were behind, if not even started. And I don't think we had any where we investigated, I'm not saying there aren't any, where there were proper evaluation and accountability mechanisms built in to the enactment of that framework. And sometimes there wasn't even an implementation plan for that framework. Are you able to tell me how many strategies and frameworks there are current in the Victorian government dealing with issues of First Peoples?
To my knowledge, there's about 14. Yes.
There might be more.
Yes. And there could be more in development that I'm unaware of.
Heard of 11 just around land and water the other day, and we've heard of multitudes around self-determination, around education, around health, around child protection. So I would be thinking more in the 50s and 60s.
There's 11 from DECA alone.
Would it be possible to find out how many there are active?
And there's probably two things that we're crossing over on, and some of them are frameworks and some of them are strategies with actions. So there's probably two different sets of documents that we're talking about.
Mm-hmm.
I guess I was referring to the strategies and actions part, like Marung, the education one. But within DECA, there's a range of just what I'd call just framework documents, which are a little bit different to the outcomes. But I'd be happy to come back to you with a comprehensive list of those. But if I could just make the comment that I have been really proud of some of those documents and been involved in the formation of some of those documents. And in fact, some of those documents have led to outcomes where we have achieved a closing of the gap. And I think about the education one in particular.
With the early childhood.
Yes. But I am more than aware that monitoring is a big issue. And I see that some of these documents may even have the opportunity to be superseded or incorporated into an outcome within a treaty framework. And within a treaty framework, we will have monitoring. There will be ongoing monitoring of what is captured in a treaty.
I guess my point is that we've got all of these strategies and frameworks that have been in existence, and in the education space, I've been monitoring them from early 2000 onwards, with huge commitments in them, most of which have not been delivered or not been delivered fully. I'm just wondering where the accountability of your department is and your role in actually monitoring and keeping a watching brief across all these strategies.
Well, my department sits within the Department of Premier and Cabinet, so there is an accountability, and there are, I guess, reporting and measures at a secretary level. But in terms of a better system, I actually think the treaty could deliver us something better in terms of ongoing monitoring.
But isn't there a responsibility of government to be doing better now, not waiting for treaty?
Absolutely, absolutely.
Can I just ask Mr. McAvoy, Minister, not only in your statement, previous statements, and in the frameworks and strategies, where the word self-determination is constantly there. What does government mean by self-determination? Because I think for community, it might mean a different thing. So just understanding from even your own or government, what is self-determination?
But I think, I'll tell you what, there's been a view for many, many years before I came to the portfolio that self-determination was about consulting. And we've done a lot of work to try and disband that myth and break that down across government and our entities to say that self-determination is not just about consulting First Peoples. It's about embedding change and handing over power and handing over resources. And I would go to saying that many of our frameworks and strategies that we have across government do go to a part of that, but maybe not far enough, and maybe don't have allocated upfront resources against those commitments. And that might be where part of the struggle has been to continuously I guess, deliver on those.
Can you have part self-determination though?
No, you can't have part self-determination. You can't say, because I've informed as a minister, I've informed a First Nations or traditional owner group, I've informed you, I've talked to you about it, but I've made no decisions that are in partnership with you or give you power or outcomes, then that's not self-determination.
Minister, can I ask, beyond the establishment of the First Peoples Assembly and Yiduk and the Treaty Authority, that architecture, what are some of the areas that you think has been government have delivered on self-determination? What's some of the things that come to your mind where they have, beyond the ones I just said then?
Yep. It's kind of how long's a piece of string, but from my knowledge, I don't have a list in front of me, but just from my experiences, I would say the operation of First Nations kind of sports clubs through to kinders, through to languages being delivered in schools. At the heart of all of those was a self-determination process to deliver those. In terms of lands, if we want to talk about that, I would argue that some of the processes we have in place now in terms of Traditional Owner Settlement Act do deliver outcomes of self-determination. I know that there will be, probably opposing views from some traditional owner groups, but there would be some that say, yes, we have been able to achieve some of that there. So I think the ultimate self-determination, though, is going to be through a negotiation of treaty and the ongoing independent body.
I think that we've heard pretty loud and clear, Minister, that there's a lot of tension out there about everything having to wait for treaty, and government ministers and bureaucrats articulating that we haven't transferred power and resources to community. So I think it's just something that's on our minds around trying to understand how much power and resources and authority has actually been transferred over. We have heard of broken systems being transferred, and that's been articulated as a form of self-determination, or where government thinks they're, giving over control, but it's very much a broken colonial system. So it's just good to hear your perspective on self-determination.
And I don't think we should shy away from the fact that, in fact, having secretaries and having lead people from our departments and having ministers here at this commission is making a difference to the thinking and approach to self-determination.
Thank you, Commissioners. The question I want to take you back to, Minister, is in relation to reporting and monitoring. I understand from your answer about the hope that something might develop through the treaty process is an invitation to the government and First Peoples to be innovative in the way in which mechanisms might be developed to ensure that there is proper monitoring and evaluation of government performance. Is that correct?
Yeah, I mean, being quite aware of how the New Zealand model, the Treaty of Waitangi operates, and knowing that there is already processes around the world in other countries, but they're one in particular of having an ongoing monitoring role of all treaties is a really important element for delivery. Yeah.
Do you accept, though, that there's a role for an administrative monitoring body as well?
Yes, I do.
It can't be left to formal complaints and litigation to ensure that an agency performs its obligations under a treaty.
No, I see, rather than litigation being an outcome of that mediation and some authority for the body that is doing that work to be able to approach any entity that's part of that is meant to be delivering on that outcome to be interviewed, discussed, mediated outcomes.
This topic is one which will come to the fore in treaty negotiations, you expect?
Yeah, I do.
I just wanted to turn your attention to the question of First Peoples' disadvantage.
Yep.
and discrimination against First Peoples. Perhaps continuing on from Commissioner Lovett's observations, do you accept the proposition that for non-First Peoples, and perhaps particularly so for government officers who are non-First Peoples, that the effects or the causes of discrimination and disadvantage sometimes have to be explained to them because of their perspective? They are unable to see how a particular policies or actions affect First Peoples.
Absolutely, I do. And I think that that's a huge failing of our history and education system.
And do you also accept that First Peoples are more acutely aware of institutional and structural discriminatory conduct against them?
Are they acutely aware? Yes. Yes. Do they always take action? No, because quite often they don't have the capacity to do that.
Do you believe that this is an open question. Do you think that there is resistance within government or government agencies to oversight in relation to treaty, particularly independent oversight by First Peoples?
I think there's still more work. I wouldn't make the judgment that there's resistance. I would say that there's more work that needs to be done for better understanding.
And as Minister, part of your role is to take the government down that path and ensure that they get access to the materials that will give them the information.
Yep, and the demonstrated leadership.
Has there been discussion within government about oversight of performance in the treaty space by First Peoples, in addition to the Treaty Authority?
Sorry, can I get you to repeat that?
Yes. Has there been discussion within government about oversight of performance of the treaty processes by First Peoples, in addition to the oversight by the Treaty Authority? So I'm not suggesting by the Assembly, but more generally by First Peoples.
Oh, look, I can't. I'm a bit concerned about talking about what's being discussed inside the cabinet room, but I can say that this has certainly been a consideration of the leaders across our public service when they've come together to talk about treaty and self-determination.
I think you've given us our answer anyway, Minister. Do you think, without speaking about the cabinet discussions, that there is general support for First People oversight of the treaty processes, so that agencies and agency heads are answerable to First Peoples about their performance?
Yes, I do.
Now, I would ask you, Minister, at this stage to have a look at a document for us. Perhaps your council provided you with the article from. Oh, yes, it is a convenient time. Before I move on to the next item, we should take a break, commissioners. A 5-minute break, if that's suitable.
Yep. Yeah, that's fine. Yep.
Okay.
Yep.
Yeah. Then I haven't actually done.
Commissioners. Minister, I just before the break, I was going to take you to an article from the Age newspaper. This is an online printed version of it from the 3rd of May 2024. Do you have a copy of that in front of you?
I do.
We have a copy of that on the screen, please, operators. So just for context, this is an article from the 3rd of May 2024, and your statement to Europe was dated the 18th of March 2024. So perhaps 2 weeks later.
Mm-hmm.
Now, this article is in relation to the report delivered by Europe, titled Europe for Justice, and you can see a copy of the report on the front page of that printed article.
Yes.
And there's comments in that article from the Assembly, First People's Assembly of Victoria co-chair, Mr. Ruben Berg, and there's also comments from Ms. Narita Waite. And then if you go to the third page of that document, at the bottom below your picture, it says, she, referring to you, rejected suggestions that the response from government showed the government was not listening. You accept that adequately contextualises this document?
Yes, that's my quote.
Yes, and then there's a quote from you which goes across the bottom of the page over to the next page, and then a further short piece from you. Can you just read that to yourself? Yes?
Read it out loud.
No, read it to yourself.
That quote I can understand.
I just want you to read the words attributed to you at the bottom of the third page, going over to the fourth page.
Yep.
Just read them to yourself, because I want you to tell us whether they're the words that you said, because newspapers can sometimes get these things wrong.
Yes, I did say that.
Okay. Can you turn back to the bottom of page 3, starting with the words I can understand? Can you read for the commissioners that quote?
I can understand people have had to battle the effects of colonisation for more than 200 years, that they want a quicker solution to some of the problems that we've talked through and brought to the surface. I understand the frustrations, but we have an obligation as a government to the Victorian people to make sure we get the laws and changes and policy settings right, and that's why we're going to take the time to do it and get it right.
Minister, I suggest to you that those words, particularly the last two sentences, are not the words of a champion of the treaty process.
Well, I would disagree with you.
Minister, you're familiar with the term command and control.
I am.
And you understand that it means that it's a reference to government using, particularly with respect to government power, government using its power and making decisions, flexing its power, notwithstanding the impact or views of others.
No, that is a reflection not on my comments are not a reflection on the recommendations of the Commission being right or wrong. My comments are a reflection on government being able to deliver and making sure that they deliver in the right way is what my comments go to.
Well, I'll put it to you this way, Minister. On reading those comments, it would appear to any person reading those comments, that you are telling the people that were complaining about the government response, being the First People's Assembly, the Europe Justice Commission, that the government knows best and it will make its own decisions about these matters.
No, That is not the intent of the quote. That has never been my intention. My comments are about the government being able to deliver it in the right way, the outcomes that were suggested.
But Minister, can I ask you this question? You start by saying that you understand the frustration of people. And do I understand you to mean by that the lack of movement is actually causing suffering in the Indigenous community by reason of government or progress being slow on these matters?
I think there's harm happening to Aboriginal people as an effect of colonisation that we're trying to address 200 years worth of damage and destruction in numerous months is probably not realistic.
No.
And what I am saying is that out of 46 recommendations, 43 were either supported or supported in principle or under consideration. And the reason we've had to do that is to make sure the government's response is right.
Sure. But I'm just trying to understand the concept or understanding you have of the effect of delay, and wondered if it was the same as what I've gleaned from even the short time of hearing evidence on the Commission, that this is actually an everyday lived suffering.
Mm.
Is that the way you understand the way many in the Indigenous community feel? This is a lived history on a daily basis.
Yes. With the justice system, yes. With child protection, yes.
And in relation, we'll probably get to it, land and water injustice as well.
Yeah.
Because it's certainly a strong impression that I've got, and it becomes very clear when you hear enough Indigenous people talking about their current situation. So with that understanding, I'm just wondering why the proper response to any sort of question of timing of change is not to actually give specific end dates. In other words, would not, in the light of that understanding, it have been better to have given some sort of a timetable as to when the outcomes could be expected? Because this is entirely open-ended, isn't it?
I did commit to bringing an implementation plan around these, both back to Cabinet and providing that to the Commission as well. And I did state that in the press conference that I made there.
But it's the when. And what I'm suggesting to you is that against the background of the sensitivity of Indigenous people, isn't it important to actually provide clear definition rather than we want to get it right, so we need to take time without any, I'm saying the Indigenous community with that sensitivity has no idea about what the timeline is.
Yep.
And I'm really not trying to focus on the Commission earlier reports, but rather a general proposition.
Yep.
Is it not important in the context of your ministerial responsibilities to be clearer about time definitions?
It is, but sometimes those time definitions are not my call in terms of the system of legislation and its passing into Parliament. We can, and same with positions at Cabinet. So I can say I estimate to have done this by X month, and the process does not back me up in terms of the parliamentary flow of legislation or the timeframes that things need to go through cabinet. And unfortunately, that is the reality. And there is an opportunity for me to nominate some dates, and then if they're not met, then I'm just letting people down. So there is a commitment that I have given to come back with a full implementation plan by the end of the year. Now, I'd like to do that sooner, but whether the processes allow me through the parliament, and that's not just a position that government can commit to, because there are other parties in the parliament that change our timetables.
I am really very interested in the issue of delay in implementation, which we'll touch on, I'm sure, later on. And you've given one insight into how difficult it is, and that is, as I know, the whole process of government and getting legislation drafted and into a legislative program and so forth. But the problem is that if you've got people who are daily suffering the consequences of a failure to act, then isn't it necessary for those processes to be changed?
Yes, there is a sense of urgency. Yes, there is.
Precisely. But how do, I mean, I'm thinking of our recommendations, and how is it that we can make recommendations that actually reflect that sense of urgency? Because if we simply sit back and say, well, the process of government is the process of government, and that's just too bad, everyone's caught up with that.
Yep.
This is, and I think you've accepted, a very particular area of sensitivity, and it might just not be appropriate to say, well, there's a legislative queue and that's the way it is. And
I think it goes back to kind of every single report that government has to respond to in this space and in any space, and that is, there's not an independent mechanism for following up on this. And I think that actually the pathway we're on with treaty is actually going to deliver us that sort of mechanism to help us implement things in a timely manner. I think and it sits outside, once we have some legislation, it sits outside that process or is regulated by that process. But right now we don't have that. And it's become evident more and more to me in reviewing the evidence that has come to this committee and in preparing for today, just how much that is something that we need.
I think in the broad,
Just to reiterate an earlier point, surely we shouldn't have to wait for treaty for government to deliver on the commitments that it makes itself.
Yes, and we've made some commitments in response to the first set of recommendations from Europe.
I'm talking more about all the other strategies and all the other things that aren't delivering.
Yep.
Surely we shouldn't have to have a treaty to actually have government take responsibility for enacting the obligations it itself has made.
Yes.
I think for myself here as well, in the response about the you can understand the effects of colonisation from more than 200 years ago. But Minister, we did hear in our last round of evidence around criminal justice and child protection that I think it may have been the Attorney General, but if it wasn't the Attorney General, it was someone from one of the Secretary or Deputy Secretary from Justice, confirming that the government, in making those bail reform laws, understood that it would have a disproportionate impact on Aboriginal people receiving bail. So again, trying to give confidence around implementation, whether it be our recommendations or things moving forward, knowing as well at that point in time the government knew that those laws were going to have a disproportionate impact to further embed our people in the system.
It's Yeah, it's a government policy that caused a little bit of debate.
Minister,
Mr. McAvoy, can I just, on
Commissioner.
Commissioner North's point about recommendations and timeliness, we as a commission have had to gain trust of community around a royal commission, and everybody has said another royal commission. And again, there's nothing really committed to. Do you feel it's already an injustice for our people who are coming forward, telling their truth, to read those comments? And I will point out Reuben Berg's comments under it. Aboriginal people are all too familiar with the promises written in the sand. So the Assembly will be looking to hold the government to those in principle commitments in treaty negotiations with the next round of truth-telling recommendations. We'll be wanting focused evidence-based outcomes that can really lock in so there's no wiggle room. I think it's that first, we're all too familiar with promises written in the sand. As the Minister, how do we keep continuing to get our people to continually tell their stories? And this isn't the first time they tell them when they come. We've all worked in community and you've heard them.
Yep.
How do we continue the hope of our people for justice?
And the quote that you just used around the writing commitments in the sand is the very reason I've been very guarded in making sure that our commitments are not written in the sand and blown away, that they are written in concrete or etched in rock that they can continue on and be delivered in. And sometimes when governments just respond to recommendations and inquiries and say, okay, yeah, in principle, we accept them all, you'll find 7 or 10 years later that hasn't happened. And I mean, we've seen that with the Aboriginal Deaths in Custody Royal Commission. And we want to make sure that the recommendations that come out of this are not just dealt with in treaty. Treaty will be a major component, or the reports that have been, and strategies and frameworks and have been committed with Aboriginal people across Victoria over many years now, are picked up and captured, potentially within a treaty process going forward. Now, that might not be the first statewide treaty. That's why we've always said treaty or treaties, because it gives us potential to lock in a mechanism to measure and deliver and hold accountable the commitments that come out of treaty.
So you've got an implementation plan, or you're going to produce so when could you commit to that being?
In terms of the Yuruk first recommendations, by the last quarter of this year. Yeah.
Thank you.
Minister, in your words that are quoted in the article, the emphasis seems to be on the obligation of the government to make sure that it gets the laws and changes and policy settings right. But you accept, though, Minister, that the Attorney-General came to this commission and was cross-examined for a day, asked questions about reform of the bail conditions, which were so terribly affecting the First Nations, First Peoples communities in Victoria. It's not an issue that has taken the government by surprise, is it?
No.
Government is well aware and has put great levels of work into understanding the deficiencies and the need for bail reform.
Yes.
And so to say on the 2nd of April or the 3rd of April that that we need to make sure we get the changes and policy settings right, it gives the impression that you hadn't thought about it before that point, but it's not the case, is it?
That's not correct. Of course, we've thought about the change that is required. That was directly in response to the detail of the recommendations that have come out of Yuruk.
If you turn to the next page of the article, the chair, Yuruk chair, Professor Eleanor Burke, midway down the page, said commissioners expected to see progress on the 15 recommendations still under consideration. And she's quoted there, given the weight of evidence presented throughout the inquiry, which included deeply personal accounts from First Peoples witnesses of suffering, which many continue to experience every day, commissioners are disappointed by the government's decision not to support 3 recommendations. These recommendations were not made lightly. They go to the heart of addressing ongoing injustice for First Peoples. And I suggest to you that hearing the questions from the commissioners today, it only reinforces the impact of the suggestion that the government's not ready to proceed on these matters. It's a further denial of First Peoples, is it not?
No, I don't agree with you. I'd say having a positive position on 43 out of 46 recommendations and then a realistic way forward that the government has identified those recommendations and broken them down is a realistic approach. And I just go to those 15 that are under consideration. What we mean by that is that there's further policy and legal analysis and drafting that needs to happen from the government's perspective in regards to those.
You're not suggesting to this commission that it's a numbers game, Minister, are you? And that they should be satisfied because the majority of things have been supported. That's not what you're saying, is it?
No.
No. Each of these recommendations deserves to be dealt with on their merits. That's correct, isn't it?
They do, yes.
And what's happened is that in your response, you've conveyed to the Victorian First Peoples and this commission that the government will get to it when it's ready.
No, the government is already getting on with the work that needs to be done around responding in detail and implementing the recommendations that we've said we'll support in full and doing the further work around those that are identified in principle and under consideration.
Can I just ask that while the government's doing that, can they take into consideration the high rates of child removal, the deaths in custody, the ongoing trauma of our people? Because while we're waiting, I can reassure you that a child this morning has probably been taken. And if that can't be taken into consideration, I don't know why we're here. Because we have to face these people, our people, who have been dispossessed, constantly traumatised. And as Mr. McAvoy has just said, these aren't just words on papers and it shouldn't be a numbers game. These are our people. And we don't take our job very lightly, and we have to sit here every day and hear the trauma again and again. And I hope that government takes into account every child that's removed daily from our hospitals, from their homes, from their parents. And I pray to God, not that I even believe in him, that there is not another death in custody, that we have to sit here and listen to the families again. So if government could take those into consideration, you can understand our frustration. And that's not just mine. It's our people's. And you've heard it. I've heard it. And I just wanted to reiterate that. Thank you, Mr. McAvoy.
I think, Minister, I'm wondering if it's accurate to say that this might be a problem of communication, because, and it applies generally, the expressions that you've made and other ministers have made are faultless in commitment, and I accept that those are genuine commitments. But when then you get, in effect, a lack of apparent action, it really shatters the foundation of trust that this is a serious exercise. Now, you've set up this Royal Commission. that's an indication of seriousness. You don't do that every day. Yet it's 6 months before there's a communication about what's going to be done, and then it's in sort of the vaguest terms. Now, I would expect that internally there's much more definition about where you're going and what the thinking is. And I'm just wondering if that assumption is right, whether the problem is not sufficiently sharing that, because I'm continuing to look at the distance between the faultless statements of policy and then the result of it. And I keep asking, well, why, accepting that the statements are genuine, why is it that, for instance, and I'm not very keen to drill down on, work that this commission has actually done, because there are plenty of other examples which we'll get to, but here we have government expressing all the support that Indigenous people could ever want.
Mm-hmm.
And rightly so, sets up a royal commission with all the attendant solemnity and cost involved in that. And then the report is delivered. It takes 6 months before there's a response, and it is in the broadest terms. Now, maybe you can share with us that there's more substance to the response, but absent that, it looks really discordant with the seriousness of problem and the actions and the statements of commitment.
I don't think there is a question around commitment. I think there is always a question, and when we come back to the kind of definitions of self-determination, we get to the heart of where we, in the flow chart of self-determination, we get through the kind of first 5 things when it comes to change. But then when we get to handing over of power and resources, that is always the brick wall. That's always the hard part. And I would say that it is still a journey that governments and departments are still on. And quite frankly, getting those decisions made and that really significant change made, particularly recommendations 1 and 2 that were handed down, and some other really big decisions that are in our frameworks and strategies, that the handing over of power and resources is a tough thing. And don't think that our government sat on a report for 6 months and didn't debate it. That is certainly not the case. We did at many levels talk through all of the recommendations. I quite frankly did not want to come to this commission and not have a response out there. Now, it may not be to your satisfaction, and I understand that, because as you've said, Commissioner, you've said that you've got to face you've all got to face the people that are most affected by this all of the time. But I want to give you the confidence that with a bit of time, some change will happen and power will be handed over in these spaces. And that is something that I'm very committed to, and not just me, but the Premier as well.
You're confident that that's going to be able to happen through the treaty process, Minister?
I am, yes.
Thank you, Commissioners. If you can just turn to paragraph 21 of your statement, please, Minister. In that paragraph, you observe, I recognise that first peoples in Victoria were not dispossessed of their lands by the idea of terra nullius alone. You're not a historian, are you?
No, but I smile because I think the 1 A+ I ever got in my life might have been on this topic, but
Are you telling me you'd like to be cross-examined on this, the history of Victoria?
on my year 11 essay of history, no, I don't want to be.
Yes, and you're not a lawyer?
No, I'm not.
And And so somebody's assisted you with this idea that the First Peoples of Victoria were dispossessed by the idea of terra nullius?
I think I don't need a legal briefing on this. I've had plenty of conversations directly with First Peoples around the culture and history that was here before settlement to know.
So that's the basis for your understanding?
Yeah.
I suggest to you that the notion of terra nullius was something that was brought to the colony pretty much after all of the dispossession had taken place in Victoria, and it was an excuse used after the fact. And I don't expect you to be able to respond to that, but I put it to you anyway.
I go on to say that terra nullius is a fallacy, and
yes, I understand that. But what I'm suggesting to you is that it wasn't the basis upon which the dispossession took place in Victoria in the first place.
no, I don't believe that was the sole reason. No,
it wasn't the reason at all.
Yeah.
Is what I'm suggesting to you. It's a principle that was brought to Victoria sometime after most of the dispossession had been done.
Yes.
So I put that to you so that we're clear on that point. Now. You recognise in that paragraph that private settlers and colonial authorities used violence to establish control over First Peoples' lands and waters and forcibly remove people to make way for the Europeans. Yes?
Yes.
And then you refer to the Royal Commission into Aboriginal Deaths in Custody, which took place in which the final report was handed down in 1990.
Mm-hmm. Yep.
So we moved from the initial stages of the colony to the 1990s, where we're looking at the over-incarceration and high rates of death of Aboriginal people in custody.
Yep.
And we come to today, where there are recommendations from this Truth-Telling Commission about how numbers of people incarcerated might be reduced, and how the suffering of Aboriginal people might be reduced, and it's a fair proposition, isn't it, to say that this is just a continuation of what started when the British first arrived on these shores?
I think it's important to acknowledge the ongoing effects of what happened when the British arrived on these shores, and how they are still, the dispossession and the trauma is still evident today. No,
I'm saying to you that the effects are still occurring. So that it's the process of colonisation is still being rolled out.
Yes,
against
because
First Peoples.
Yes, we have white-based laws. Yes.
Yep. Yeah. One moment, please, Commissioners. So, one view of the treaty process, Minister, might be that the failures of the original colony are being sought to be put right through entry into present-day treaties, when they're the things that ought to have been done at the outset.
Yeah, it's definitely an attempt at addressing injustice.
And in order to address that injustice, is it the government's view that First Peoples need to be put as best as possible into the position they would have been had they been treated with lawfully and with dignity in the first place?
Yes.
And so it's from that foundation that the treaty process is being launched, is it?
Yes, that's a foundation.
And it's in recognition that the First Peoples of Victoria were here with their own systems of law and government and connections to land, ownership of land and waters prior to the arrival of the British.
Yes.
That under First Peoples laws and customs, they still possess those rights and still exercise and operate according to those systems of laws and governance.
Sorry, can I get you to repeat that?
It's accepted that First Peoples in Victoria still operate and observe their systems of laws and governance and still maintain their connections to land.
Yes.
And part of the treaty process is trying to bring the Western system that the colony of Victoria has brought to this place into line with a more equitable accommodation of those laws and customs and governance.
Yeah, and to support the reconnection of those laws and customs.
In your statement, you've referred to killings of First Peoples by government agents and other actors. In this hearing room, we heard evidence from Dr. Bill Pascoe about the various massacres that occurred in this colony, this state, many of which were committed by non-state actors, private citizens. In making your statement, are you seeking to distinguish the government in terms of its role in the deaths of those people from those which were committed by private citizens?
Did you say, am I trying to distinguish or distinguish? Yeah. No, look, I think any atrocities to that level that were murders and deaths during that time, even by a third party, there's still a state government responsibility to have enforced the law, and murder is against the law. And I think certainly there was a failure by governments at the time, and depending on which time frame you're talking about, whether it was the state government or a Commonwealth entity, failed to protect our First Peoples.
Thank you. And so these are matters that are properly within the ambit of any treaty negotiations as between the state of Victoria and First Peoples?
I think certainly discussing and the state's failure or the Commonwealth's failure at the time to protect First Peoples is absolutely something that's on the agenda. If you're asking me to commit to what dates they are, I can't. I'm not a lawyer, and I probably need to get...
I haven't asked you that question, Minister.
Yep.
In addition to the use of various mechanisms, including terra nullius, to avoid payment of compensation to First Peoples in Victoria, there's also been windfall gains, if I can put it that way, to the colony and the state by reason of the sale of lands,
Mm-hmm.
keeping of wages of people who are subject to protection legislation, the fruits of the resources, the royalties, the lease payments, all of those matters have increased the state's accounts. You would agree with that?
Yes.
That all came as a result of this notion that the colony or the state could avoid payment of compensation to First Peoples.
I can't talk about the thinking of previous governments, but I would assume that was part of the reasons for those decisions. Yeah.
Mm. Did you hear the evidence from Minister Demopoulos earlier this week?
Only parts of it.
Were you made aware of the evidence in relation to the admission of the way in which the legislation was passed in order to avoid avoid payment to First Peoples?
If I could clarify what piece of legislation or time.
Sorry. I'll come back to that question. I just need to make sure it's right for your purposes.
Yep.
In order to ensure the question's fair. You're aware of the issue that was covered in the papers about a $2 billion avoidance by the state.
Yes.
Yes, you are.
Yep. Can I recall is this in regards to forestry?
Yes.
Yep.
Have you been briefed on that matter?
No, I haven't.
I suggest to you that it was accepted by Minister Demopoulos that it appeared from the material produced to the Commission that action was taken for the purpose of avoiding liability to First Peoples in Victoria. Do you accept that?
This was the setting of the threshold at a point that could never be reached, you mean?
Yes. Yeah. So this occurred in 1994.
Yep.
And the particular piece of legislation, the Plantation Corporations Act, was.
Yep.
The important date was the commencement of the Native Title Act, and the briefing was very clear that the action ought to be taken by the government in order to avoid the operation of the Native Title Act. Does that sound familiar to you?
Yes, I do now know what you're referring to, and I think that memorandum of briefing that might have gone up to government at that time was pretty disgraceful in its content, in denying native title being, an issue here in Victoria or applicable. In terms of the details around the forestry decisions that were made at that time, I mean, to be honest, in 1994, I was spending most of my time organising rallies on the streets against that government. So for a myriad of decisions that were being made that were just unjust.
Those briefings come from the department, don't they?
Yes, they do.
And you accept,
or entities related to the departments. Yeah.
and you accept that such briefings reflect an attitude and an approach to First Peoples and First Peoples' rights that sees First Peoples as the enemies?
Having read that particular piece of information that you're referring to, the briefing note, absolutely, yes. There's no doubt that in that era, that's how First Peoples were perceived by the government at the time.
And it would be hard to draw a distinction, I suggest to you, between that era, 1994, and the things that were occurring in the colonial era of the colony of Victoria.
I would say that with the pre-1994, there might have been in the years before that some progress for First Peoples representation, but I also note that that was the time in which many of our prominent Aboriginal leaders that have fought against injustice were most active. Some of our elders that are around today. So I think it reflects some of the policies of colonisation? Yes, I do.
And that type of attitude you'd accept as one of really an active denial of any justice or empowerment for First Peoples?
Yes.
And how confident are you that there are not still within the Victorian government people who might still hold those views and attitudes.
How confident am I that they don't? I don't know that it is my role to oversee the attitudes of every one of our hundreds of thousands of employees across the state. Do I think it's the attitude of our leadership teams? No, I don't.
You accept that not only does it take a committed leadership to achieve these significant changes, but it also takes a committed bureaucracy.
Yes.
And you can't tell this commission that people of the same ilk as the authors of that briefing to the minister in relation to the Plantations Corporation Act still don't exist within the Victorian government.
Well, they don't exist in positions of significant power. No, I'm confident to say that.
If it's not, I'll just explore that for a moment. You accept that treating Aboriginal people in such a way has at its heart a racist approach to Aboriginal people, First Peoples rights.
Yes.
And do you accept that repeated and excessive delay on behalf of government is not also a symptom of a disrespect for First Peoples?
I can see how delay can be interpreted as being disrespectful, yes.
One of the things that has been discussed in these hearings in this week, indeed, is the extent to which there is government inertia at play in terms of resistance to big reform. You would accept that all government agencies have a tendency to want things to stay the same, to maintain the status quo?
Yes, and I would say that in regards to most change, not just change in this space.
But you can't say, though, that the delays that are being experienced by First Peoples in Victoria in terms of countless numbers of frameworks and projects and processes and reviews are not affected by people who have a more greater intent to derail the process than just being an example of inertia. You can't say that they don't impact on the performance of the government, can you?
I'm really confident that a lot of our public servants are very committed to seeing the injustices and demands and needs met of our First Peoples. I am confident of that. Is that to say that there aren't people with different views that work within government at different levels? Possibly.
Would you accept that it's probable that people who disagree with the notion of First Peoples self-determination that continue to exist within the government within positions of power?
I feel confident that people that we nominate for positions of power are signed up to the agenda that this government signed up to. If there's a particular leader that you're alluding to within government that is a problem, I'm happy to consider that.
What I'm trying to get to, Minister, and I apologise if we've gone the long way around, but when there are so many reports and reviews that are outstanding, there's got to be some reason for it. There's got to be some reason, and this commission is tasked with the job of finding out why these things don't happen, why there's these delays in the performance of things that government has committed to, why there's delays in response to reports that people have put extraordinary amounts of energy into.
But also, I have made the point already that that I acknowledge that some things have taken time to respond to, and that has, in some cases, been perceived as disrespectful by First Nations people. But can I just say that I think in our time in government over 9 years, there's been tremendous change. There's been tremendous change that has been implemented in partnership with our First Nations people. This Truth Telling Commission is one of those, and our legislation for treaty is another example of that.
Do you say that the government can rest on its laurels in this regard? Is that the point that you're trying to make?
We can never rest on our laurels. And I've also been very much from day one, 8 years ago, when we talked about a treaty process, always committed to the fact that the government needs to continue to move forward with change and meeting the needs of our First Nations people without deferring everything to treaty. I could see that would be something that that government could possibly pivot to, and that was a commitment that myself and other ministers through the cabinet process made.
Can I just ask, Mr. McAvoy, so you said 8 years of commitment, and the government's got a strategy or a policy or a whatever you want to call it of self-determination. Can you give me an example within those 8 years of true self-determination for First People?
Certainly, working with Aboriginal Aboriginal Victorian housing organisation and talking to them about their needs and wants led to the handing over of 1,400 properties, if not more. That was during my time, it was 1,400 properties for Aboriginal Housing Victoria to be able to manage. I might not have the acronym right for them, but yeah, I mean, that's just one example. That's one example.
Is that true self-determination for them? Do they still need government funding to run and?
Yes, there is funding around their kind of core business, but I would say that the handing over of properties for the management and titles of those properties meant that there could be true decision making made by that organisation as to whether those properties needed to be renovated, sold off, how they were managed, and how they were, appointed through community to those that needed the housing.
And if we ask them, they'd say that's true self-determination for housing.
You would have to ask them. I think that they've done some amazing work since they've had that opportunity to have the titles and ownership of those properties. And I've also seen many other Aboriginal-run organisations who were given the mortgage or title to their properties make significant change and they make their own decisions around where they're located and how they're delivering services. They're just, I recognise they're small steps, but they're examples.
Thanks.
Thank you, Commissioner. If it's a convenient time, we might take another short break and we will then go through to 1 o'clock. So if we could have a 5-minute break now.
Yep.
Thank you. Thank you, Commissioners. Minister, I want to take you now to a different topic, namely the issue of the soldier settlement scheme, which I understand that you're familiar. That's correct. And in particular, I want to ask you about your understanding about the way in which the scheme was operated and the complaints of First Peoples in relation to that scheme.
Well, firstly, I'd just like to say that whilst the scheme was put in place to recognise and reward the efforts of Australians that fought in the First and Second World Wars, and upon their return, the way that the government and governments, I should say, because it was a joint federal and state scheme, treated First Peoples and our soldiers, First Peoples soldiers that returned, was disgraceful. And I acknowledge that many people were discriminated against and lost opportunity to become holders of that land through that scheme. And I'm deeply saddened to read and hear about the returned soldiers, how they were treated, and the ongoing effects that that's had on their families.
Are you familiar with the legislative arrangements in relation to that soldier settlement scheme or the schemes?
I don't know the legislation, but I do know that the delivery of the schemes was split between the Commonwealth and the states.
Perhaps if you might refresh your memory, if you could look at paragraphs 40 to 42 of your statement, commissioners might want to follow.
Oh yeah, it was called the Discharged Soldier Settlement Act of 1917, but I can't say that I'm familiar with the details of that act.
Are you familiar with the extent to which people in Victoria were provided with lands on return from service overseas?
Yeah, I mean, not only were returned soldiers, First Peoples returned soldiers discriminated against by not being included in the program, and I think there might have only been 2 that were, but I think that it was compounded by taking Aboriginal reserve land and reallocating that to non-Aboriginal people was yet another part of the terrible injustice that happened with this scheme.
And at paragraph 40 of your statement, in the last sentence, I'll just read it. A state commemorative project found that by 1930, the Victorian government had acquired 2.5 million acres, which is noted as being just over 1 million hectares through the Discharged Soldier Settlement Act 1917. And of that 2 million acres, 2.5 million acres, the understanding is, your understanding is that only two Aboriginal servicemen gained access to that scheme and to any lands under that process.
That's correct, and I named them as Private Percy Pepper and Private George Winter McDonald in the statement.
You're also
Sorry, am I right in thinking that the total number who served, Aboriginal men that served, were about 90?
I think across both wars.
We're talking about the First World
War. I don't have that number, but I'm happy to get that. I thought in total we were talking around 1,000 people across both wars, but I'm happy to.
And how many are still alive?
I don't actually have that information.
It just struck me that it's an obvious injustice.
Yep.
A lot of it is a long time ago, and like, why wouldn't you fix it? I mean, I know what you've said in your paragraph 46 and 47 about the problem. It's a Commonwealth state responsibility, but in the end, I mean, there's sort of no question about the unfairness of that.
No, there is no question. And until working on this statement and being briefed on all of the issues that your Justice Commission was considering with these rounds of hearings, I was not aware of this. I was not even made aware of this in the first term that I was minister back in 2014 to 2018. But it is certainly something that I think we could work with the federal government on coming up with a solution. And I've had initial discussions with the federal ministers who, again, were completely unaware of this scheme.
The problem with the Commonwealth is that it would have a much larger canvas, so it might be multiplying the number of people. But for Victoria, if Victoria just decided, well, it's something that we have to do something about, it just doesn't strike me as something that should be difficult to address, should it? I mean, it's being such an obvious, immediate land injustice issue, and as just as a demonstration of commitment and goodwill, I would have thought, however many people there are under, probably under 500 now.
Yes, and there's redress schemes that currently exist that could be modelled quite easily with this. But to be honest, Commissioner North, I've not had the opportunity to have a conversation with any First Peoples entities to talk about what would be sought in a redress scheme. But happy to take that on board and have a look at it.
I imagine the answer might be money.
Yeah, well, other redress schemes have money as a part of that, but also counselling is another part of that. There's a myriad of things that come with it. Yeah.
Just with that, Minister. So, Uncle Johnny Lovett gave evidence at Yaluk.
Yep.
And talked about this particular thing along with a myriad of other things that he wanted to express with us, truth telling. So just picking up on that last point, there's other people, I'm sure, but you'd be open to having a meeting with him to talk about soldier settlements?
Yes, I would be.
And further to the evidence that we received as well, that there was a reference to two land transfers around soldier settlement. Now, we heard some evidence from one family descendant in particular of one parcel of land out of the two that was enabled through that process was someone who had one leg, and the country that was returned to that individual was so rocky that they had a hard time to be able to do anything with it, to be able to walk across it, because of only having one leg, not being able to use that to do any farming for that particular point in time, or any really self-determining practices to be able to set them up for the future. So I know it's not your issue, but just putting it out there that was one of the land transfers that was unusable for that individual who had suffered deep trauma in their life, to be able to come back and think that they're getting something for their contributions to the country, as in Australia as a whole, and to not be able to access and use that land meaningfully and effectively is really, gutting to hear that. Yeah,
and the injustices, we're not just about the land scheme as well, but I don't need to tell you, but, when Aboriginal veterans went off and fought for this country and then came back to be discriminated against time and time again, whether it was the RSL, whether it was acknowledgement in their communities for what they had done for our country, let alone the land scheme. It's a massive disgrace.
I agree, and I still hold the stories from my grandfather, who was went to World War II and fought for this country, and came back and lived through those discriminative times, and watched his people suffering as well. So those stories sit with me as well through this process.
Big wounds.
Thank you. Now, I'd just like you to look at the letter on your letterhead that has been handed to you, and I'd ask that it be put on the screen. It is a letter from you dated the 7th of March 2024 to the Honourable Matt Keogh MP, Minister for Defence Personnel, Minister for Veterans Affairs in the Federal Government. You've got a copy of that letter?
I do.
Copy of that on the screen. Can we just zoom in a little bit more, please? You've alerted, in this letter, if I can just paraphrase it, you've alerted the Federal Minister to the fact that the issue of the soldier settlement scheme is being considered by the Europe Justice Commission, and you are in the fourth paragraph. You say, "I'm following up on a commitment made to the Commission by my predecessor to raise First Peoples and equitable treatment in relation to the schemes at the Commonwealth level." You note that the schemes were a joint state Commonwealth initiative, and then identify that potential recommendations made by the Commission in its next report due March 2025 may require a joint Commonwealth and state response. And the next paragraph says, "I would welcome the opportunity to discuss this further once the Commission's recommendations are published in 2025.
Mr. McAvoy, what date was that?
This was the 3rd of March 2024.
Thank you.
Sorry, 7th of March 2024. It's some 11 days prior to the Minister's statement.
Minister, I'm a little puzzled why you need to wait till March next year to discuss the issue. I mean, you say in the letter that it's an obvious inequity, and we might say that in a year's time or 6 months' time or whatever it is, but it just opens the aspect for people, First Nations people, to say, well, there are these commitments, and as I've said, I think they're genuinely expressed, but when it comes to doing something productive, I mean, why wait? We all know it was very wrong, like exceedingly wrong. Anzac Day is coming up, and you say, well, let's wait till March next year to talk about it.
That's to talk about it with the federal government. That's not to take action as a state.
Yeah. But the way I understand your thinking, and I might be wrong here, but you talk about it as if it is something that you need to go forward in tandem. I mean, I don't see that is necessary myself, but it seems to be the way thinking. And if that's so, then I don't see why there should be a delay. And as I say, the problem about it is that it feeds into a view that the commitments made are, well, say I think they're genuine, but I don't know that would be obvious to others if they see examples like really clear, simple examples like this one. Can you shed any light on my reactions?
Yeah, I understand your reactions, and I want to clarify that that doesn't mean that the state government is not going to respond on this matter beforehand. And I honestly think that in my discussions, I not only wrote to the Deputy Prime Minister and the Minister for Indigenous Affairs, I met with them to discuss it as well. I got the impression that a recommendation from this commission would be of great assistance in getting the federal government focused on moving on this. Now, that was just my interpretation in a very short conversation. I guess that's why the timeframes were included based on the recommendations from the Commission, but that's not to say that the state is not going to progress anything on this topic.
And if the Commonwealth is using the timeline of this commission, then perhaps the transcript of today could be shown to them to say that that would be quite illegitimate and bad for the vision that it gives to Indigenous people about how seriously their obvious injustices are taken up.
And I know that there is consideration being given by the Commonwealth and other states about a way forward with truth-telling across the nation, and it may not be a bad thing to be sharing some of the transcript from today.
So the communication with the federal government, just so we're clear, is on the basis that the primary legislation was Commonwealth legislation, and the scheme provided for the Commonwealth to reimburse the state for the cost of compliance with the soldier settlement scheme. Is that correct?
Yes.
And so we understand that the state of Victoria is saying, well, we would like the Commonwealth to contribute to any compensation scheme that's established.
Yeah, and also, and I don't know because I haven't had the conversation, but maybe the need for apology needs to come from different levels of government as well. That could be a factor in redress of this matter.
It is the case that it's unlikely that there will be areas of land that can now be transferred to the families of the returned servicemen, isn't it?
It is unlikely.
We're really talking about hard redress in terms of any monetary compensation, and soft redress in the forms of apologies and counselling and other matters.
Yes, that's not, I'm saying yes because that's my experience with other redress schemes, and I don't want to preempt what might be in this one.
Just take you back to Commissioner North's observation that it's not a complex scheme to establish. That the injustice is clear, and that Victoria could do it on its own, or could establish the scheme and say to the Commonwealth, we expect you to contribute before it commences.
I'm not so caught up on the whether the federal government participates or not, but rather what we would include in the scheme and how we would apply it. And we've done schemes with and without the Commonwealth support as to what we see needs to be redressed. And I certainly feel that land allocations in this circumstance would go a long way, but I don't know that they're a reality, and I'm also not sure that is what, in some cases, the families would want. So that would be needing to be fleshed out more from a state perspective.
You understand, just as a matter of history, I suppose, Minister, you understand that that Uncle Johnny Lovett was one of the very first witnesses in this whole York process in what from memory was June or July 2021. So that the government's been on notice about this particular complaint the whole of that time, and we see your correspondence to the federal minister suggesting that you'll be in touch after this coming report. I suggest to you it's not consistent with any urgency to resolve this matter.
I disagree. I think the government has a potential to address this matter sooner and not just the date that's included in this letter. This letter has a commitment in it that was more around the appetite of the federal government, not the state government.
Well, the letter doesn't say that the state government's going to go ahead regardless of what the...
No, it doesn't, because we haven't made that decision.
Minister, Commissioners, I might at this point hand over to my learned junior to take up a line of questioning with the witness up to the lunch break. And I anticipate that there will be a number of questions for the minister after lunch.
Yeah.
So at this point, we might go until 1:10, given that we started at 10:10. But in any event, when this evidence is concluded with Mr. Goodwin, it'd be appropriate time to take the lunch break.
That's fine. Thanks, Councillor.
Thank you, Minister.
Thank you, Commissioners. Minister, I'm going to ask some questions about the recent First Principles review. Your statement commences discussion about the First Principles review at paragraph 272 on page 55. Now, I'm correct in saying that the review concerned the operation of the Traditional Owner Settlement Act. That's right?
Yep.
And Mr. McAvoy will be asking some questions. He'll likely be asking some questions generally about the operation of native title and the Traditional Owner Settlement Act. But just by way of background, the Traditional Owner Settlement Act was passed in 2010 as an alternative pathway to the settlement of native title claims in Victoria.
Yep.
And as I understand it, there were two focuses of the review. First, to respond to the High Court's decision in Northern Territory and Griffiths, which is typically referred to as the Timber Creek decision, and explore what guidance might be drawn from the decision to the calculation of compensation under the Traditional Owner Settlement Act. And then second, to examine whether the rights recognised under a settlement agreement under that Act, particularly in template agreements, are appropriate or could be strengthened. So is that your understanding of the purpose of the review?
Yes. Yeah.
And when I'm referring to compensation in the course of my questions, I'm doing so in the Native Title and Traditional Owner Settlement Act context. So the governance arrangements for the review were that there was a First Principles Review Committee made up of Victorian traditional owners and an Executive Policy Owners Forum made up of senior executives from government departments and agencies. That's right?
Yep.
And is it your understanding that members of the committee were comprised of Victorian traditional owners, including those that worked for traditional owner corporations?
Yes, that's my understanding.
And so those people were likely drawn from people who are intimately aware of and involved in the operation of the Traditional Owner Settlement Act.
Yes.
And then as recorded in the review itself, between 2019 and 2021, the forum of senior executives was made up of 29 representatives from all the affected departments and agencies.
Yep.
And so the report is structured in such a way that there are recommendations made that are joint between the committee and the forum, and recommendations that are individual to either the committee and the forum.
Yep.
And it was intended at the time that the final report of the review would be provided to the Attorney General, and to the extent necessary, the Attorney General would take matters to Cabinet for consideration.
Yes.
Now, if I can bring up paragraph, we have it at paragraph 272. We can just highlight that paragraph. You mentioned in the final sentence that once again it was Victorian traditional owners who led the way by identifying the key areas in which the Traditional Owner Settlement Act was considered to have not delivered on its aims. Are you acknowledging there that traditional owners themselves advocated for and pursued the review?
Yes. Yeah. And the need for change.
And then the terms of reference neatly set out what appear to be the concerns of Victorian traditional owners that led to that review. So if I can go to pages 89 and 90 of the review. Assists its DPC.0011.003.0098. There we have it. Minister, apologies for that delay. This sets out the scope of the review, and so is it your understanding that this highlights some of the concerns, or at least areas of discussion, that Victorian traditional owners wanted to engage in with the government?
Yes, but I just want to, for the record, to know that I was not actually Minister at this time and involved in this process.
So the Attorney General had portfolio responsibilities at the time. And so it was Jill Hennessy, the Attorney General, who endorsed who was responsible at the time for the terms of reference, and established the review.
But I also, at that time, was not in Cabinet. Yep.
On reflection then, as currently with portfolio responsibilities, you understand that at least at that time, these were the concerns of Victorian traditional owners.
Yes.
And so I'll just highlight a number of them under the content of natural resource agreements, which is an agreement that is a potential part of the settlement package under the Act. The fifth dot point highlights the commercial use of natural resources. And then under the land use activity agreement, there's reference to the community benefits formula in light of the Timber Creek decision. And so in lay terms, the community benefits formula is a formula used to compensate traditional owners for land use activities on their country, as an alternative to the Future Acts regime under the Native Title Act. Then if we go to the second part, there's also, again, under community benefits formula, there's a reference to categorisation of land use activities. And then under the recognition and settlement agreement, there's reference to the funding agreement and the implications of Timber Creek with respect to negotiation of settlement packages. So, Minister, just like Mr. Patton from the Federation yesterday, you'll be glad to know I don't intend to take you through the entirety of the report. I just want to focus on certain recommendations. So if we can go to page 27 of the report.
I actually don't have my hard copy with me, but I'm happy to look at the screen.
And I'm also happy if that hard copy is provided to you. That's
Can I ask you to repeat them?
Yes, and apologies, I didn't realise that, Minister. So this is page 27. And so recommendation 1 is that settlement, and this is a joint recommendation, that Settlement Act agreements should represent a fair and just settlement for traditional owners as assessed against the listed criteria below. As the joint comments note, that's a change from the current policy of providing an attractive and fair alternative to settling claims under the Native Title Act. And the particular criteria listed there is that whether a settlement is just and fair will be judged against certain criteria, and that criteria includes whether the offer complies with and in practice implements the United Nations Declaration on the Rights of Indigenous Peoples, and also whether another criteria will be whether the offer meets or exceeds what would otherwise be available if the traditional owner group obtained a positive determination of native title. Now, just to skip ahead to the end of the story, this recommendation was accepted by the government with immediate effect, and you communicated that to the Federation last December.
Yep.
From the government's perspective, why was this recommendation accepted and why is it important?
I think since the findings of Timber Creek, that it's obviously set a new benchmark, but also really, I guess, focused governments on the real need for detailed outcomes to be fair and just. And I think that is, probably.
And then if we go to Principle 2 and Recommendation 2 on the next page. So Recommendation 2 states, and then this is an individual recommendation of the committee. The recommendation states that calculation of compensation should not be limited to activities occurring post-1975. Now, you understand that that's a response to the fact that under the Native Title Act, compensation is only available for acts attributable to the state that occurred after the enactment of the Racial Discrimination Act.
Yes, so that's the federal law. Yep.
And the forum, in putting its comments, if we can just go over, I know we have it, under the forum comments, essentially the forum commented that the issue was beyond the scope of the review, but that the issue should be referred to the Minister for Aboriginal Affairs, as the title was then, for potential progression through the treaty process. Now, I don't want to quibble with that conclusion, but do you as Minister understand the desire of Victorian traditional owners who participated in the review for any just and fair settlement of claims to consider pre-1975 acts?
Do I understand why they would do that? Yes, I do. Yes.
And what's your understanding of the basis of that desire?
The injustices and dispossessions that occurred before that time would be the driver of that.
And it'd be right to say that this is particularly so when the fact that most acts that either wholly or partly extinguished native title in Victoria were likely to have occurred prior to 1975.
Yes.
Is it your view that treaty negotiations will not be similarly constrained and take a more holistic approach to the impacts of the history of the state on Victorian traditional owners and their relationship to country?
I think treaty will give us a new mechanism that may be well outside the scope of the Traditional Owner Act. I'm not going to preempt it, but I think it will give us an opportunity for new mechanisms without the restrictions of these timeframes.
And I suppose without the restriction of the legal frameworks that constrain particular issues around the enactment of the Racial Discrimination Act and its effect on native title law.
Yes, correct.
So if I then can go to recommendation 18, which is on page 45 of the report. Just while that's coming up on the screen, do you have it, Minister?
Yeah, commercial use.
Yes, under the
water.
heading commercial use of animals and water, and we have it now. Currently, a natural resource agreement, which may also form part of the settlement package under the Act, may allow for the commercial use of vegetation and stone, but not for the commercial use of animals and water. Do you understand that to be the current position?
Yes.
And still, in regards to the commercial use of vegetation and stone, it isn't a given under a natural resource agreement, but is essentially an area for potential negotiation with the state.
Yes.
Now, both the committee and the forum agreed that the Traditional Owner Settlement Act should be amended to provide for commercial use of animals other than fish. But in essence, the forum did not agree that water and fish should be included. Now, you explain in your statement, and I'll just get the particular paragraph for your benefit. This is paragraph 280.
Yep.
You mention, you say, in relation to certain recommendations not agreed, nor, and this is just over the page on the top of page 57, nor did the government agree to a right to commercial use of fish and water, as these resources are fully allocated for commercial use or nearly so. What can you explain in more detail that reasoning as you understand it?
No, I can't, because I think that this is a little bit outside my portfolio as to the allocation of commercial use for fish and water. But is this something that could be put back on the table during future negotiations for treaty? Yes.
And you mentioned in the next line, however, government is taking steps to enable traditional owners' participation in the commercial water and fish regimes. Do you know what those steps are?
No, but I'd be happy to get some more detail and come back to you.
Now, Minister, a cynic might say that those two natural resources, water and fish, are particularly commercially valuable, and that other vested interests, both third party and the government itself, are not keen on sharing a piece of the pie with traditional owners. What's your response to that?
Change takes time. That's what I would say to that.
And do I take it from that change, that type of change requires sensitivity around particular vested interests?
No, I don't. I don't want to comment on vested interests of commercial users, but I think the government's view has been in the past that these were things that could only be negotiated via a Traditional Owners Settlement Act. And whilst this review has highlighted some of the shortfalls perceived or shortfalls that have been found by traditional owner groups, that's not to say that these are not issues that could be pursued through a treaty or treaties process, particularly on a geographical basis.
And you understand that the desire of the committee in making this recommendation was simply to open up these matters for negotiation with the state, and in the context that they would not necessarily be a given in the natural resources agreement. In those circumstances, couldn't some of the issues that you've highlighted, including the pace of change, still be relevant, but nonetheless be open for negotiation for traditional owner groups considering entering into a natural resources agreement?
Into the future, yes.
We've heard evidence from multiple traditional owners that economic empowerment is essential for self-determination, and there are significant funding challenges that restrain their capacity to deliver benefits for their community. You're generally aware of such issues.
Yes, I am.
Can you understand why traditional owners might be frustrated when, in circumstances where they want to negotiate with government on the commercial use of natural resources to build an economic base that means they are self-sufficient, they are in fact stymied or delayed in their capacity to do so?
Yes, and I understand that frustration, and I acknowledge with 200 years of colonisation, there are commercial arrangements in place that if the government was to say, we're going to negotiate right now on these, when we've got commercial arrangements in place, that could be in breach of what we're doing. That's not to say that into the future, when areas become available, that couldn't be part of a treaty negotiation.
And you mentioned in your statement at paragraph 281 that you intend to keep an open line of communication with traditional owners on these issues, and suggest that government must respond in good faith to the traditional owner proposals put forward in treaty negotiations. Does that include thinking innovatively about commercial use of natural resources on country?
Yeah, of course it does.
And the Commission has heard evidence of significant trade routes that operated across Victoria prior to colonisation, including various trade routes between First Nations themselves. So that really suggests that commercial activity in Victoria predates British colonisation. That's right.
Yes.
So it's fundamental to access to cultural rights and traditional rights for traditional owners.
Yes, it is. Yes, I recognise that.
I want to ask some questions about the length of time it took to finalise the review. It was originally intended for the report to be presented to the Attorney General by the 1st of August 2020.
Yes.
Now, of course, no one foresaw the outbreak of a global pandemic at the time the terms of reference were endorsed. But nonetheless, at paragraph 273 of your statement, you note that the review was not finalised until November 2023. Is that when you received a final copy of the review?
Yeah, it was around that time. I couldn't actually lock in that November date, but yeah.
But the end of last year sounds about right?
Yes.
And although I understand that the Attorney General, when she and her predecessor had portfolio responsibilities, and then when you took over portfolio responsibilities for land justice, received briefings on progress of the review over its course. So you note at paragraph 274 in the final sentence that the...
Can I just clarify?
Yes,
actually,
yes.
going back, when I say yes, it's only from September last year to, because it was a different minister that had the portfolio. But yes, she would have received.
Yes, that's and apologies if my question was not clear. I was putting that whoever had portfolio responsibilities was receiving briefings. So, now you note at paragraph 274 that the final report was authorised by traditional owner partners in March of 2022. Do I take it by that that's the people who participated on the committee?
Yes.
Now that's about a 20-month gap between authorisation by traditional owners and finalisation by government. What's the explanation for that gap in time?
I think there's a number of factors. That certainly COVID did play a part in it. Certainly changing ministers in portfolio areas did play a part in it. But I think, most importantly is to say that it's not in line with my expectations that it should have taken so long. And I apologise to the traditional owners who were involved in this process, who gave up their time to be part of this review, that it took so long.
Because those issues that you've highlighted don't really explain conduct post-March 2022, do they?
In my statement, no.
And do you accept that timeliness itself is an element of fairness and justice?
Having that point made to me today multiple times, yes.
And do you accept that when all relevant agencies were actually part of the review itself through the forum, that there really shouldn't have been such a delay in response from those agencies?
Yeah, it should have been responded to sooner.
I know this is a variation on a theme, as you've already highlighted, but in your view, how does the government ensure that its own delay does not become or is no longer endemic to First Nations affairs?
By trying to capture some of these outcomes in a treaty process that has an independent authority keeping us on track for implementation. I think that's the pathway forward.
Can I ask you, Minister, again, I'm really sort of curious to understand what the sources of delay are, and you have explained earlier today some of them, but this particular one, is there some reason that sort of explains a systemic issue, or is it just that it got sort of left behind in departmental consideration?
No, I think that the issues that I outlined are, firstly, and probably one thing I didn't talk about. I mean, yes, COVID delayed a lot of things for us. A change in minister, another thing, but also responsibility shifting from the Attorney General's portfolio to Treaty and First Peoples was another reason for the delay in this. And I note that in between myself and the previous Minister for Treaty and First Peoples, there was an acting minister in that time whilst she was on maternity leave. There is a myriad of issues as to why, and they come down to the highest level of government structure at the moment. Yeah.
Now, as I mentioned, the forum itself listed 29 senior executives of government departments and agencies as members between 2019 and 2021. And now, while it might be said to be laudable that there was such cross-departmental representation in an important review such as this, at the same time, the flip side of the coin is that I wonder if you're concerned as Minister that sometimes in government processes there are, to put it bluntly, too many cooks in the kitchen.
Yeah, from time to time there are too many cooks in the kitchen. I don't dispute that. And that's because departments have their own interests and their ministers' interests at heart, and they want to make sure that they're protecting their patch, their resources and their delivery points. And there's nothing wrong with that, except that when we want to make change, we need them to be able to be flexible to do that. And we need new mechanisms around which we do that. And that's what I'm hoping, or I know, that a treaty option will bring to us.
And are you aware of any community sector group or industry group that regularly has to deal with the full gamut of the bureaucracy to pursue their rights or interests as First Nations people in Victoria have to?
Yes. And that would be women. And it's just as tough to get change.
And in that respect, two of the most marginalised groups in the state have to navigate the full plethora of bureaucracy in order to advocate for reform. You'd accept that. And there's a tension there, really, in terms of when we're talking about the capacity and resourcing available to those people to be able to engage with the bureaucracy.
Yes, and when we have First Peoples employed in our bureaucracy, we find that things move faster in that space. And when we have more women in leadership roles in bureaucracy, we find change moves faster.
I just want to take you to the letter that you wrote, Paul Patton, the CEO of the Federation of Victorian Traditional Owners Corporations, in December last year. And if we can just go over to the next page. And highlight B and C at the top of the page. Can you see that clearly?
Yes, I can. Yeah, it's okay. Yeah.
And so in the letter, the government states that it's agreed in principle to the other joint recommendations.
Yep.
And you note an interdepartmental committee has been established to consider policy, financial and community implications of the proposed changes. Shouldn't that really have occurred in that gap between March 2022 and November 2023?
I'm not sure that actually that work could have started without a cabinet direction around these recommendations.
So again, that highlights the significant impact of that delay on the capacity to deliver on the recommendations of the review.
Yeah, it probably contributed to the timeframes, yes.
And would you understand why traditional owners, particularly those that participated in the review, might think that this is just setting up another process, again, in blunt terms, kicking the can down the road rather than delivering tangible reform?
No, because we've committed to, we have made commitments within the recommendations to make progress, and we've identified others that need to be raised in the treaty negotiations.
Just finally, I want to take you to some remarks of the committee in the introduction to the review. So this is in page 18 of the review itself.
Just before you move on.
Yes, of course.
Minister, in relation to B, the acceptance in principle is subject to some fairly major further considerations, particularly the last one. Has that been advanced at all since? Do you know the financial implications?
Has it been costed? Yes. Has costing work commenced? Yes. Has budget allocation been made? I can't say ahead of the release of the next budget.
And then what about the possible legislative processes?
Has consideration been given to the recommendations that require it? Yes, there has. Has drafting commenced? I'm not sure. I'd have to come back. Yeah.
And is there have you shared the progress with the the TOs who are on the other side of the table?
Not as yet, not in detail. No.
And I should say as well, the review's been shared with the First Peoples Assembly of Victoria.
Yes, it has. Yep.
So just finally, to take you to some remarks of the committee as an addendum to the executive summary, and if we can highlight the third paragraph. And I won't read all of it out, Minister, but just halfway through, the committee states that that while it is understood, there were long delays while the forum considered positions put forward by the committee. Presumably this time was spent in internal debate, and while it is understood that whole of government decision making is complex, yet externally from the position of the committee an excessive amount of time was spent on issues long articulated by traditional owners and for which it was assumed forum members would be well versed and ready to propose alternatives. Indeed, it is notable that some departments sought to amend recommendations and add last-minute conditions up to and during the final drafting of the report when there was no time for further discussion or debate. Are you disappointed that the traditional owners involved in the process felt that way and felt so strongly that they wanted to write an addendum to the executive summary?
Yeah, I mean, I welcome their views outside of that process, but yeah, I understand their disappointment.
And what would you like to see, that we've discussed it in part, but what would you like to see done in the future to ensure that such a situation, or even the perception of such a situation for Victorian traditional owners, does not occur during the treaty negotiation process?
I think because the process is quite starkly different in that when we come to the tables, and this has been a key part of the legislation of advancing treaty, when we come to the table to negotiate, we come with that authority, and we have to prove that as part of the process, both on the government side and on First Peoples side. That, in my mind, in practice, means that last minute amendments and time wasting will not be a factor.
I'll just add something to that. We've spoken about time, of course, and how long it takes to get everything done. And then you've got no time for further discussion or debate about a recommendation. I just find it quite ironic that some things can take as long as they need. And then when it comes back to responding to something or for further discussion or debate, there's no time because it's the final draft. So I just wanted to make that comment because I find this comment quite ironic considering what we've spoken about today.
Yeah, and I'm disappointed that was the case as well.
You said time's a lot of barrier, and picking up on Commissioner Hunter's point there, but also would you say that also leadership can be a barrier as well around showing leadership? I'm not saying you specifically, but just more broadly around being courageous. Treaty is about a brand new future, shared future, and it's going to take considerable leadership, demonstrated leadership to be able to make that happen from both sides. Do you want to make any comments about, so we hear a lot about time and constraints and so forth, but what about leadership that needs to be shown?
Yeah, I absolutely agree. And I think overcoming the fear of change and the fear of transfer of power is a big factor. And the only way to do that is to lead and use examples of how actually empowerment is a good thing, not a bad thing. And, you know, I failed to mention before when we talked about self-determination that where we have handed power and resources to First Nations organisations, we have seen some of the most extraordinary outcomes in closing the gap targets. And I think about that primarily in the health space with health organisations who, through a cultural lens, have been able to get the most extraordinary health results once they've got full self-determination over the work that they're doing. And I think there's still a lot of work around tackling tackling that shift of power and change out of all of our government entities.
And what drives you in that context?
Because I have seen people change in the time that I've been in this role. I have seen significant shifts in people that I've worked with for many years that I didn't think would ever change, and they have, to become more receptive and less combative and more trusting of handing over power and resources to First Peoples. And that has only come through an understanding of the history.
Thank you, Commissioners. I think it's, if it's an appropriate time to adjourn lunch, we're in the Commissioner's hands. We can start back at 2:10 with a view of finishing at 3:10, although that might go over a little bit. We can check with the Minister about her availability, but if that's a convenient time to restart, we're comfortable with that.
Yep, we're happy with that. That's great. Thanks. We'll adjourn for lunch.
Good.
Thanks, Council.
Thank you, Commissioners. Minister, I'm going to ask you some questions now about the Mabo decision and native title in the state of Victoria. This commission has heard evidence from a senior Yorta man, Uncle Cole Walker, as to the hurt and pain and trauma that was caused by the native title hearing process. His evidence was that when I had to give evidence, they knew I was a local bloke and that I had knowledge from my elders, but they crucified me. What hurt me is that the judge said I was a deliberate liar. I think we had a lot of pressure put on us. You'd feel terrible when you'd be giving evidence. Why did you have to give so much evidence? Why did you have to tell them this? Why did you have to sit there for hours being cross-examined when your old elders told you these things? At a hearing on the 27th of May 2022, Uncle Cole told Uruk that the Yorta case, which ran for over 10 years, caused pain at the time and has caused ongoing hurt for the community. Just this week, the Commissioners heard evidence from Uncle Graham Atkinson. In his statement to Uruk, Uncle Graham explained the Yorta native title outcome led to the Traditional Owner Settlement Act, and his statement provides the injustices and inadequacies of the native title system have been starkly exposed by the December 2002 negative High Court decision in the Yorta matter. Claim in the Victorian context, the Yorta decision suggested that the litigation of native title was virtually impossible and land justice would require very different arrangements. And during his evidence, he confirmed that from 2003 to 2014, he was the chair of the Native Title Services Victoria, so he was right in the centre of those discussions. In his evidence to Uruk, he spoke of the ongoing hurt and suffering. On the same panel was Marjorie Thorpe, and she said that on hearing of the result in the decision, it was devastating. It was devastating, and I think to see that happen to the Yorta people was of concern to other groups and how they would fit. But I think we were quite naive when we went into this native title process, and I think the legislation itself is flawed from the start and doesn't really address the needs of First Peoples in this country. Evidence also from Karen Jackson on the 15th of April. She was devastated by the High Court's decision. She said, I was really devastated at the time, and I still get emotional about that time. I was there when that decision was handed down. I just couldn't contain myself. There was so much horror and pain in that decision. I got on the crane and cried all the way back to St Albans thinking, what the hell just happened? She said, that can't be right because Yorta is so strong and Yorta has always had connection. Yorta mob are everywhere. We talk about country and we're connected to that space and we know that space. It was one of the worst days of my life. It was a shock that happened based on a white man's story, not a black fellow's story, and all of that telling of connection and belonging. There was also a land justice round table held with the Jaja Warren Clans Aboriginal Corporation in Bendigo on the 25th of November 2023. And at that round table, Uncle Gary Murray said words to the effect that the native title process contributes to genocide because it erases distinctions between clan groups. Uncle Gary explained that small groups such as the Wairuru and Norai, Ilum and the Burrup were effectively erased as a result of the Yorta decision. He then suggested that as a result of new evidence prepared by those groups of the land included in the Yorta Yorta claim, there were grounds to make a Section 13 variation application under the Native Title Act to reopen the Yorta Yorta decision. We're also aware, and we understand that you may have been made aware, Minister, that there is correspondence to the Attorney General referred to in a brief from November 2008 in which Gary Murray, on behalf of the Wairarua Native Title Group, raised again, in that occasion, the use of Section 13 of the Native Title Act to go back and have a look at the decisions in relation to native title in this state. Are you familiar with Section 13 of the Native Title Act, Minister?
I am.
And do you have any, or does the state have any position about whether Section 13 of the Native Title Act may be used to revisit some of the matters that First Peoples have described as injustices?
Before I come to that, if I could just acknowledge the terrible outcomes that Yorta Yorta people faced with that decision being made, and to say that I've heard directly, I've been significantly yelled at for a long period of time in meeting with Yorta Yorta leadership coming into the role the first time. And I'm disappointed that the government of the day took the decision they did with the submissions that they put into that here in Victoria. And I apologise that that happened. I am always open to discussing reactivity of claims. I've not had that expressed to me by any of the Yorta Yorta leadership as being a desire at the moment, but that's not to say it isn't. I don't know. It's not something that's been expressed to me, but I guess traditional owner groups are welcome to approach the state around support in their native title claims going forward. I think we're a completely different government to the one that really contributed to the further dispossessions and cultural acknowledgements of the Yorta Yorta back when this case was heard.
Thank you. So is the message that comes from the evidence that you've just given that if the Yorta Yorta people wanted to make some representation to the state about the application of Section 13 to revoke or vary the determination in their proceedings, it's something that the state would give full consideration to?
Yes, I would talk to them in good faith with that.
Asking a question. Make objections. Yeah. I don't propose to go any further. Excuse me, Commissioners. My learned friend raised an issue with me. I think we're resolved, and I propose to move on from that issue anyway. Now, I just want to go to the Traditional Settlement Act as foreshadowed by Mr. Goodwin before lunch. The paragraph or the paragraphs of your statement which attempt to deal with the Traditional Settlement Act are 257 and 258 of your statement. If you wish to follow, Commissioners, and you might turn there, please, Minister. So you've described the Traditional Owner Settlement Act in paragraph 257 as a recognition of traditional owner group rights in all public lands and waters within a defined geographical boundary.
Yes.
Further, that the return of public land through grants of freehold and Aboriginal title,
Yes.
and that Aboriginal title is the grant of public land to traditional owners for the purpose of joint management with the state. Yes.
Yes.
Which is conditional on the traditional owner group agreeing that the state continues to manage the land in partnership with them.
Yes, that's correct.
And then at paragraph 258, there's a reference to ongoing procedural rights and compensation in relation to the proposed future uses of public land.
Correct.
And funding in lieu of native title compensation for acts done.
Yes.
Prior to the date of settlement, and for the operation of the traditional owner corporation.
Yes, that's correct.
So by the date of settlement, I mean the date of the agreement.
Agreement. Yep.
Not 1835.
No, of the agreement.
Access, use, and management of natural resources.
Yes.
And joint management of certain parks and reserves.
Yes.
And finally, an ILUA, an Indigenous Land Use Agreement under the Native Title Act to address native title matters.
Yes.
Now, there has been a response from the state in the form of in response to a request for information. You're aware of that request for information from the state?
No, if you could give me a bit more detail.
It was to the Land Justice Unit, Department of Premier and Cabinet. I might just start by taking you to the maps.
Maps.
If we can get, sorry, I'll get the operator to take. One moment. So you've got some maps in front of you.
Yep.
Now there is a map. Emily.
Yes, I've got those.
There is a map in front of you which sets out the areas that are subject to the where registered Aboriginal parties have been approved. Can you see that?
Yep, that one. Yep.
Yes, that's right. And there is a second map which shows Native Title and Traditional Owner Settlement Act settlements. If we could show the second document, please. And if we look, we can see on that second map that it's hard to see on the screen, but the areas which have a cross hatching and are covered by a native title reference to a native title determination show that there's both a native title and a Traditional Owner Settlement Act outcome. That's correct?
Yes.
And that map largely corresponds with the first map for the registered Aboriginal parties.
Yes.
If you could just put those down for a moment. Now, there are some Traditional Owner Settlement Act agreements with recognition and settlement agreements only. That's correct.
Yes.
And they are Judge-Warren
Yes.
in 2022, Tungarong in 2018. That's correct.
Yes.
There are others with native title settlements only, and they are the Gunditj Mara in 2010.
Yep.
And the Gunditj Mara and Eastern Ma, Part B in 2011.
Yes.
And the Eastern Ma Peoples Part 1 in 2023.
Yes.
And the dual ones are the the Wodjabollock and the Gunai Kurnai in 2005 and 2022 for the Wodjabollock, and 2010, 2022, revised in 2022, the Recognition and Settlement Act and the Native Title Settlement in 2010 for Gunai Kurnai people.
Yes, that's correct.
So in your statement, this is now, if you can turn to paragraph 264, you note that since 2010, an additional 5 traditional owner groups have entered into negotiations with the state for a Traditional Owners Settlement Act settlement, but these negotiations have not yet concluded, and also that groups either sought to prosecute their native title recognition via the federal court, or there were ongoing difficulties in resolving questions about the appropriate traditional owner for a traditional owner group for country. Yes?
Yes.
And at paragraph 266, if you can just proceed to that paragraph, there's an observation or a statement that the state's current policy is not to support simultaneous pursuit of native title and traditional owner settlement act outcomes. Correct?
That's correct.
Now, there is a table setting out the outcomes in relation to the Traditional Owners Settlement Act matters in the yes, please. There are some late changes to the documentation which were provided in response to a request for information that my learned friend's just alerted me to, and I might give her the opportunity to just explain those changes.
Apologise, Commissioners. The course of preparing for this morning, we identified some errors in the table. They're the numbers, and we've corrected them by hand. Well, I've corrected them by hand in this version. We've emailed them to our friends, the instructing solicitors, and what I'd propose to do is seek to replace, there are 2 pages affected. There's one at page ending 0097 and one figure at page, which is consequential change, at page 0092. I can hand up those hard copies with my handwritten change to reflect those changes that could perhaps form the tendered version of the document, if that assists the Commission, while a markup has been provided to the solicitors assisting, so that we can make sure that we have the right figures. I apologise for the error, and it was inadvertent and identified very recently in the course of preparation for today.
Commissioners, I think I don't think that anything turns on the updated figures. It doesn't. It's not an issue which we wish to pursue in any way, and perhaps the amended version could be provided to the Commission in due course, rather than a handwritten markup. Okay, thank you. So, might have your version. Yes. The document we're talking about is the Native Title 1993 and the Traditional Owners Settlement Act 2010 Land Justice Unit, Department of Premier and Cabinet response to a request for information. Do you have that in front of you?
Yes, I do.
Now, what I would ask you to do is turn to page page 96 of that document, where you can see the table.
Maybe I don't have that because I've got a paper that's only got 37. I have it back. Yeah,
So it's
Yep.
in the top right-hand corner, you'll see some numbering.
Yep.
And the document we're looking at is in fact table 5, I think. And on your document, yep, you can see a table 5, native title determinations. My apologies, commissioners. Sorry, table 11. Witness, I'm sorry. With all this changing around, I've got myself a little confused here. So you can see table 11, and table 11 is the outcomes committed to up to October 2023 for traditional owner groups under the Traditional Owner Settlement Act 2010.
yes.
You can see that. It lists 4 traditional owner groups: the Gunai Kurnai, Judja Warrung, Tungarong, Wodjabolek, Jadwa, Jadwajali, Wagaya, and Jabberwock peoples.
Yes.
And that table sets out various aspects of the settlement agreements that were entered into by those groups. In the left-hand column, you can see that there is a reference to settlement package quantum. Yes.
Yes. Yep.
And in that column, in the you will see, firstly, for the Gunai Kurnai, there was a 2010 payment of $18,923,472 over 4 years, and a similar payment in 2022, $18,866,000 over 4 years.
Yes.
With respect to the Judja Warrung, a payment in 2013 of $12,050,000 over 4 years, and in 2022, a payment of $36,305,000 over 5 years.
Yes.
What's the reference, Mr. McAvoy, to the ongoing amount?
I'll ask the minister. Certain things. You understand the reference to the ongoing amounts?
I actually don't know.
They are payments that are made annually.
Outside of that stipulated.
Yes.
Yes.
But they're
At the end of that specified period of 4 years. The initial amount is over 4 years, and then after 4 years until a new figure in 2022. I don't know.
Yes, Commissioner, those payments are ongoing to fulfil the obligations of the traditional owner body according to the LUAs and the operations of the traditional owner body, and so they're ongoing amounts. In addition to the amounts that are specified. And similarly for Tungarong people, in 2018, there's a figure of $29,380,250 over 4 years, with an amount of $1,594,000 ongoing. And for the Wodjabolek and other groups, in 2005, there was 2.4 million over 5 years, and in 2022, up to 47 million and 60,000 over 5 years, and 2,570,000 ongoing. Those payments, though, they are payments. The lump sum payments are said to be in payment of all compensation liability for native title. Is that correct?
Yes, I believe so.
That's the terms of the agreement that the treasury line bodies are required to execute, that they won't bring a compensation claim under the Native Title Act.
I might have to get some more information on that.
We can get that information from other sources, Minister. That's okay. Now, in the next on the next row, we see the agreement area, and in each of the cases, the agreement area is substantial and measured in areas of square kilometres, thousands of square kilometres. So for the Gunai-Kurnai, it's 22,800 square kilometres.
Yes.
And for the Dja Wurrung, it's 17,370 square kilometres. And similar figure for the Tangarong and for the Wodjabolok and other groups. It's 35,830 square kilometres is the settlement agreement area. Now, the Crown land in all those cases takes up some substantial amount, perhaps with the Dja Wurrung standing out as only making up approximately 2,700 square kilometres of the total of 17,000. Can you see that?
Yes, I can. Yes.
But in the other cases, it's closer to 10.
Yes.
Give or take 10,000 square kilometres. And if we then go over the page, and we have the Aboriginal title land, you can see that?
Yes.
So the Aboriginal title land, can you just explain to the commissioners what the Aboriginal title land is in the Traditional Owners Settlement Act? You've referred to it in your statement, Minister. It's the land that's transferred, but it's subject to condition that it's operated and managed as a national park, isn't it?
Yeah, that's correct. And I've got a list here. For example, Gunai-Kurnai, in their recognition in 2010, had Aboriginal title over Knobs Reserve and Mitchell River, Tarrawalunga National Park, and I could go on. There's quite a large list.
Yes. So there's a significant number of parks that have been made the subject of Aboriginal title.
Yes.
But all of that Aboriginal title is subject to the condition that it's operated as a national park.
That's correct.
And the arrangement is a joint management arrangement. Yes.
Yes.
And the traditional owners, it's not like it's freehold title, is it?
No, it's not.
The traditional owners can't build a house on the land.
No.
They can't sell it. They can't adjust it to raise funds, to adjust animals on it. They can't farm it.
Yes, that's correct.
They operate it as a national park. So in effect, it's a continuation of the property as a national park with some joint management responsibilities. Is that fair?
That's fair.
And so then we move to the column or the row below, which sets out the freehold title land. So just so we're clear, that is land that is transferred under the Traditional Owners Settlement Act as ordinary freehold title.
Can I get you to repeat that? Sorry.
So the freehold title referred to in the last
box, yep.
The last row of that table. When there's a reference to freehold title or freehold land in the Traditional Owners Settlement Act, it's a reference to ordinary freehold.
Yes.
Ordinary freehold that you can take a mortgage over and you can lease and you can develop and you can live on and do all the things that people expect to do with their freehold land.
Yes.
And so
I think though, is it still subject to, local government regulation?
of course,
Yeah.
It's a freehold land in the way that ordinary freehold.
Yeah.
And so it's subject to planning regulations and environmental regulations.
Yes.
But the point that I'm getting to is that the figure for the Gunai Kurnai, in terms of the freehold land they get, the land that they actually get in the same form as everybody else has their land, is approximately 159 hectares.
Yes.
That's correct?
Yes.
Out of a total of, what did we say, 22,800 square kilometres of land. The outcome is that they receive 159.82 hectares. That's correct.
Yes.
And you would agree with me that that's a speck in terms of the vast amount of land over which the agreement's been struck.
Yes, it's a small amount in comparison to the rest. Yes.
And what the rest of the land, even though it might not sit on all fours, the rest of the land might be given as a guide of what their traditional estate was.
That's correct.
And so, out of the traditional estate that they possessed at the date of settlement, they as a result of these agreements, the best that could be done for the Gunai Kurnai is 159.8243 hectares. That's correct.
That's the facts.
Excuse me, Mr. McAvoy, can we just confirm that that's actually less than 1% of the total land?
I don't know.
I've just done it here on my calculator. It looks like it's 0.7. Yep.
Yes. I haven't done that calculation myself, Commissioner. We can get those calculations done and perhaps provide them to you during the course of this hearing block. Similarly, for the Jaja Warong, the land that was recognised is included in their agreement was 17,370 square kilometres, and their total freehold lands is 111.541 hectares. You're nodding your head. I mean, they're the facts.
Yes.
They speak for themselves.
Yes.
Facts speak for themselves. Yes. And so, for the sake of completeness, I'll just restate that the Tangerang people, their settlement area was 20,210 square kilometres, and the area of freehold land that was available to them under the scheme that was agreed upon was 63.43 hectares.
Yes.
And finally, with respect to the Wodja and others, there was their settlement area was 35,830 square kilometres, and there was approximately 420.85 hectares with a right to first refusal of purchase on a further 3.14 hectares.
Yes.
The observation that can be made from those figures, Minister, is that in terms of the Traditional Owners Settlement Act's ability to deliver to First Peoples significant lands upon which they can live, and in the words of the co-chair of the First Peoples Assembly yesterday as to his aspirations for his people, that they thrive, that they be immersed in their culture. It's hard to imagine how they could do that with a less than 1% of their former lands. Would you accept that proposition?
Yes, I would.
And so the upshot of that is that there needs to be some other mechanism or some adjustment to this to the Traditional Owners Settlement Act to allow for a much broader delivery of traditional lands to First Peoples as freehold, not otherwise encumbered. Would you agree with that proposition?
I would say that that is no doubt a key consideration during the treaty process.
And it's reasonably well known. I would submit to you that it's reasonably well known that there is very little in the way of available Crown land for distribution left in Victoria. It's either been privately acquired or it's in the Conservation or Forestry estate.
To be honest, I haven't done an assessment on what Crown land is available in these particular areas, but I do want to say that I do fundamentally believe that traditional owner settlement as a piece of legislation was also founded to give recognition to the traditional owner groups in that area. And I know we're talking about land justice, but I also think that through the process that we've undertaken, there's been great recognition given through this process. Is the process perfect? No. That's why we looked at the first principles review. Are these delivering the outcomes for traditional owner groups that they anticipated when they started negotiations? Possibly not. Is that why, one of the reasons why we're on the path to treaty? Yes, it is.
Just Minister, hearing those figures and we get the actual figures around, but potentially them being less than 1% freehold, being able to do that. How does that sit with you? Do you have any response to that? How does that make you feel when you just hear that as evidence?
I feel disappointed that the land holdings are so low, but I also at the same time recognise that if we had not put anything in place as a government and relied just on native title after the experience of Yorta Yorta, we may not have had the recognition that we have around traditional owners that have been recognised through this process. Do I think we could improve it? Yes, that's why we agreed to a review, and that's why we're on the path to treaty.
Perhaps the Traditional Owners Settlement Act can be described as a creature of its time, Minister.
Yeah, perhaps.
It was created to fill a certain gap that was identified, and its utility going forward. I would suggest to you, and the First Principles Review also suggests to you, requires some substantial adjustment if it's to play a significant role.
And can I make the point that in recent years, the Traditional Owner Settlement Act never sat within the responsibility of the Minister for either Aboriginal Affairs or Treaty or First Peoples, that it was solely in the purview of the Attorney General. And I think it's been a fantastic step forward to move the responsibility of that.
Now, page 19 of that RFI that I took you to, you don't need to go there, but you can if you want to, states that the following areas of freehold were committed to be returned as part of the RSAs. So for the with respect to the return of the 159 hectares to the, I think it's the Gunai Kurnai, 159 hectares of freehold. And then the Jaja Warang, the 111 hectares of freehold. the Tangerong 63 hectares of freehold, and the Wodjabolic 420 hectares of freehold. It's explained in pages 21 and 22 of that response, and that the state has only returned freehold land promised to the Judge Warrung, and that the return of land with respect to the others is still pending. Is that correct?
Still, I didn't catch what the last.
Is still pending, so that it hasn't actually been returned. Is that your understanding?
Be honest, I have not been briefed about that still being pending.
It would be
I'm happy to come back with further information.
well, we might be able to get that information from Mr. Cowie at Edge.
Yep.
It would be concerning, wouldn't it, that if these agreements had been reached in 2022 and 2018, 2022, that the delivery of the lands is still outstanding.
It is concerning, yes.
And not only is the amount such a small portion of the remains of their country, but that it's still awaiting return. Yes. Now, I can just take you to paragraph 270 of your statement, please, Minister. Can you see at that paragraph that there's a reference to rights under the Traditional Owner Settlement Act are recognised over 34,920 kilometres of public land, with native title also recognised over part of this land.
Yes.
We're talking about national parks and conservation estate where there's joint management arrangements.
Yes.
And so that's the reference in the same paragraph to Victoria having returned or committed to return 2,287,594 hectares of land as Aboriginal title under recognition and settlement agreements. And so the designation of that land as Aboriginal title, notwithstanding the misgivings about what that actually means, combined with the arrangements for joint management, it's not an insignificant outcome. You would agree with that?
Yeah, it's not insignificant, but we've heard through reviews and meetings and consultation that it can improve.
And so where you refer in that same paragraph as of October 2023 to the state returning or committing to return 756 hectares of public land in freehold grants, that's the total of those figures that we looked at in the table, isn't it?
Yes, I think so. I'm just looking at the reference. Yes.
Now, on page 1 of page 21 of the first request for information response, we understand that the estate has returned, if I can put it this way, and I think this is the same list you were referring. The state has returned these lands in Aboriginal title, and so there's 9 national parks and reserves, 5 national parks reserves for the Judge Warrung, 9 national parks and reserves for the Gunai Kurnai. but that the state has not yet delivered its commitment to return the following lands as Aboriginal title: the Greater Bendigo National Park, which was committed in 2013, in the 2013 RSA with the Judge Warren, the Gippsland Lakes Coastal Park, and a small remaining part of Lake Tyre State Park committed in the 2010 RSA with Gunai Kurnai. 9 national parks and reserves committed in the 2018 RSA with Tangerang, and 4 national parks committed in 2022 with the 2022 RSA with Gunai Kurnai, and further 12 national parks and reserves committed in the 2022 RSA with the Wodjabala group. What those that information tells us, I suggest to you, Minister, is that there is a bit of a difficulty with between the entry into these agreements and the formal return of the return of the lands, if we can put it that way. Do you have any oversight as to the transfer of those lands to the traditional owners?
Do I have oversight? Yes. Do I have the detail of the reasons why things have stalled? No, I don't.
It's something that you could obtain the information about?
Yes.
Would you agree that the commitment in 2013, in the 2013 recognition and settlement agreement with the Dja Wurrung people to return the Greater Bendigo National Park, which has still not been returned, is on its face a matter of concern?
It is. And in previous responsibilities in my role before taking on the Traditional Owner Settlement Act as a part of the portfolio and native title, I have been involved in other transfers of land and been quite taken aback at the time that it has taken and the level of bureaucracy that we've had to go through for a transfer of just a small parcel of land. I'm thinking about Camp Jungai when we did a handover back of that. Took probably 3 years at that time. And I honestly don't have a reason as to why those things have taken so long, but I'm happy to investigate and report back.
Is it something that could possibly be a result of departmental inertia?
Certainly, I don't feel like that is inertia of my own immediate Department of Treaty and First Peoples. I think there are significant hold-ups when it comes to transfer and title of land anywhere. I can't tell you why.
Well, on its face, 11 years since the recognition and settlement agreement for the Dja Wurrung with respect to the Greater Bendigo National Park, it seems to be an extraordinary amount of time.
It does, and I'm happy to take it up.
Really important point, because, Minister, we understand as a people and that treaty negotiations at a statewide level will happen, relatively pretty soon. But ultimately, I think you said earlier before 2026. Secondary to that, there's also been commitment to traditional owner treaties, which will probably naturally be undertaken after that. So that's still several years down the track for traditional owners that'll be having to be waiting in hope and anticipation that their aspirations will be met but realised. Still a long, I guess, keyword time again for them to be waiting. They could be waiting a number of years for them to realise and have their rights recognised. And beyond recognised, and we fought really hard for not only recognition, but also for the rights to be realised. And we give up a lot. As we've heard from traditional owners across the state that we've met with, as I've said before, over 850 expressing their views around these particular matters, whether it be native title, traditional owner settlement, or the registered Aboriginal party process. So they've put things aside to be able to come forward and gone through trauma to get there as well. And I just think that time again is do you have anything to sort of say to the traditional owners who'll be waiting to negotiate those traditional owner treaties around just giving them confidence? Yeah.
Oh, just to say that as Minister, I'm happy to follow up on those parcels that have not been progressed, particularly the ones that you've pointed out, but happy to have a look at the whole thing. In terms of a way forward with the treaty process, we have always said treaties will be on the table, not just treaty. And we do believe that these can happen concurrently into the future on a traditional owner geographical basis.
Minister, you said before the lunch break that you saw treaty as being, if you like, different to what had happened to date because from the government side, the people that would be coming to the table, I think you said, would have appropriate authority.
That's correct.
And what does that mean?
It certainly means that the negotiators will have the capacity to make commitments without having to take a briefing back through a particular department. That they can make commitments at the table whilst they're negotiating. In terms of implementation of the ongoing arrangements, agreements that are in place, then there needs to be, as I've seen work successfully in other countries, an independent body that plays a role in that.
A role of monitoring or?
Yes, monitoring.
That would be a radical change in governmental process, wouldn't it? If there were the people at the negotiating table able to say on the spot, yes, that will go ahead. Yes, the reparation package will be whatever the dollar figure is.
Yes, it is. The whole process of truth-telling and treaty is a radical process for any government. And that's why there's some resistance on the other side of politics against this. People are scared of change. But what we're hearing today, what you're hearing every day through these hearings, is that there is need for change. There's need for radical change.
Yeah. I think that Commissioner Lovett may have picked this up, Minister, but I just draw to your attention that in a media release dated 28th of April 2010 by the Premier, it was said that the Traditional Owner Settlement Act would achieve, firstly, that native title claims in Victoria will be resolved faster, fairer, and in a less costly manner. And the faster aspect of it seems to have been lost, is the only conclusion that can be drawn. Mr. Brumby said that the Traditional Owner Settlement Bill was fairer and more flexible way to resolve claims than under the Commonwealth Native Title Act, which had been proven to be too technical and costly to deliver justice to Indigenous Victorian communities. The Traditional Owner Settlements under the framework will deliver quicker outcomes, finality and certainty for all those involved in and affected by the native title process. And I think it's fair to say that those things which were sought to be avoided in the native title process seem to be firmly wedged into the Traditional Owner Settlement Act process at the moment. And they were the fairness aspects have been addressed in the Traditional Owner Settlement, the First Principles Review, and we've heard about the delivery of outcomes taking what might be described as an inordinate amount of time. Now, in a further press release, Mr. Hulls, then the Attorney General, said prior to the agreement regarding the first recognition and settlement agreement under the Traditional Owner Settlement Act, in a media release dated October 2010, Mr. Hulls said prior to the agreement under the new law, the Gunai Kurnai claim had been in court for 13 years. That on its face sounds like a long time, but we're now talking about another 11 years for delivery of under a recognition and Settlement Act.
We talked about timeliness before. I know it's a sort of a theme of the day, but if we think about the trauma that's, we talk about what happened during colonisation. Do you think this case specifically, how much more trauma that adds onto our people? Like, that's a long time.
I have no doubt, but at the same time, if we didn't have a Traditional Owner Settlement Act and we were just totally reliant in those years on native title, would we have progressed any further? And I'm not saying that that's an excuse. I'm just saying that that's the reality. We have had a lot of investment in ensuring that we've got right people for country through this process. And I think that has been a real positive outcome. Has the delays in obtaining the agreements or the flow on of the agreements affected First Peoples' wellbeing? Yes, probably it has. Yes.
The whole process to getting the land, like that's.
We have to jump through a colonial process to prove our identity. Yeah. I think I just wanted to make that point.
Yes, I think sorry, Commissioner, but that is absolutely a great point to make, and that is it's a white man's system that we're trying to apply to First Peoples law and connection, and we can see that there are failures in that.
It's important to note as well that outside of traditional owners having native title, there's been 4 traditional owner settlement agreements. Obviously, the others had native title already. Just another point I think it's important to make.
In evidence to this commission, the First Nations Legal and Research Service observed with respect to the Traditional Owner Settlement Act that it's increasingly difficult to finalise an RSA, a key problem being the lack of a determinative process for resolving issues of group composition and boundary disputes. And they're issues you're aware of, Minister?
Yes.
And that further, that despite government's provision of resources to assist with mediation, without recourse to the court or another determinative process, groups have been unable to negotiate or finalise RSAs or native title settlements. You agree with that assessment? Further, at day 6 of this hearing block, witnesses from the First Nations Legal and Research Service made the following statements regarding the failings and shortcomings of the Traditional Owner Settlement Act and native title regimes. And I'll just take you to some of those. Often, some of the land that is offered with the transfer under the Traditional Owner Settlement Act is not land that is necessarily useful. And then with ownership, there comes the cost of maintaining the land. So yes, sometimes there's been a transfer, but other times what is on offer as well. You are only offering this because it was not useful to the state. So it is not always as good as what it can appear. And so, are you aware that that might be part of the process, that the leftover pieces of land that are difficult to manage might be forming part of the Traditional Owner Settlement package?
No, I'm not. I'm not aware that it's some sort of internal policy. No.
You would accept that that they might be the parcels of land that are left over. Indeed, the ones that are not wanted by anybody else.
I don't know that to be necessarily true.
It was also stated in evidence, the promise was that there was going to be settlements and they would be quicker than the native title process. But I think in the context of the difficulty of what we talked about before, groups coming together and resolving issues and disputes, that have been very much a legacy of the dispossession made, reaching agreement is very difficult. You wouldn't disagree with that observation?
No. Can I make the point that in my statement at 282 that I do acknowledge that the state can be more creative in how we approach land justice and land injustices, and how we can work better to, and I make that commitment there, and then further down as acknowledging that the campaigns that have been run by multiple First Peoples leaders are some of the longest running campaigns that have been as part of our history here. And I really do believe that the path that we are on with treaty, and I know I keep coming back to that, will help put us on a better path with land justice.
I'll just say this much, Minister. There was other evidence from other people, even this week, going to the difficulties with the traditional owner settlement process. But to be fair, there was evidence in support of the Traditional Owner Settlement Act from Uncle Graham Atkinson. And so the criticisms, I suggest to you that the criticisms are expressions of frustration as to the Act not reaching its potential, if I can put it that way. Now, I just wanted to ask you some questions about the Aboriginal Cultural Heritage process, and that will be my last series of questions. I note that it's 3:15 and we've been going for just a bit over an hour, and I might suggest just a short break, 5 minutes.
I'm okay if we want to continue. I'm okay. But if you...
The Minister's fine with continuing, then.
I'm in your hands, Commissioners.
No, I'm happy to go. Thank you. No? Yeah.
Thank you. Minister, I have probably another 10 minutes. Please let me know if you'd like to have a break. You're familiar with the taking control of our heritage report?
Yes.
And you're familiar with the recommendations?
Yes, I am.
Report? There were 18 recommendations, and that report was delivered by the Aboriginal Heritage Council in April 2021.
Yes.
Is there anything that you can say to the Commission about the government's position with respect to that report?
Oh, just to say that I want to thank the Victorian Aboriginal Heritage Council for their work that they've done on this, and really acknowledge that our current laws are set up in a way which require, I guess, that balance around how we manage developments and how we protect our Aboriginal culture. And in terms of the outcomes from their review, I can consider really internally how we continue to work on those recommendations with the council in implementing some of the changes that we know need to happen.
In submissions or evidence to this commission, Minister, the First Peoples Assembly of Victoria has identified the cultural heritage reform in response to that report as one of the urgent items which requires action, and that shouldn't wait for the treaty process. Do you have any response to that suggestion?
Yeah, and there is opportunities for us to make some changes, and we're getting some advice around that. And we're keen to do what we can around looking at the regulations related to the Act that monitors this, and also looking at the resources that are needed for our traditional owner groups to be able to continue to carry out the work under this Act.
Federation of Victorian Traditional Owners Corporation proposes that the state accept all the recommendations of the Aboriginal Heritage Council, or 18, noting importantly that recommendation 4, which would provide registered Aboriginal parties a veto power for the destruction of cultural heritage, as a particular recommendation that ought to be adopted. So, in terms of action, is there anything that you can say to this commission in terms of the timing of the state's movement on this report?
Well, it's an internal document, and we're getting on with actually looking at the recommendations and implementing some of them. And when I say some of them are more practical and can be considered now. And for example, supporting the recommendations around self-determination for the Heritage Council, changing its name, employing its own staff directly, and having autonomy away from the current arrangements with DPC. They're things that we are getting underway and working on, but there are more significant changes that are in the recommendations, like the transfer of decision-making powers that we believe should be on the table for negotiations during the treaty process.
Is there going to be a formal description of that process, of those matters which are being put off to the treaty and those which are going to be acted on more immediately?
Yeah, and that will be communicated through a meeting of myself and Victorian Aboriginal Heritage Council in the near future.
Near future. There was also a submission from the Tangarong people, which refers to additional relevant considerations which might include the development of a national framework for protection of cultural heritage, support for devolution of Victorian Aboriginal Heritage Register to an in-house Tangarong digital record, and protections for larger areas of country as being culturally sensitive for Tangarong people. In an environment where the state is properly considering the transfer of power for a range of things to the First Peoples Group or First Nations, is transfer of power for cultural heritage decision making one of those matters that is on the table?
I think certainly the keeping of data is definitely something that will be given consideration during the treaty process.
Question I asked.
Oh, sorry, I might have misunderstood.
The question is the decision-making power with respect to making decisions regarding the protection of sites and places.
That I believe that power currently sits with our registered Aboriginal parties. Are you saying shifting that to another format?
Well, if there's a traditional owner group
outside of the registered parties, yes, that's something we can be given consideration through the treaty process.
The JARA notes that in their submission noted that it has asked the state to amend the Aboriginal Heritage Act to include those recommendations, and that's just another submission in support of the implementation of those recommendations. So you have responded to this report's recommendations in some sense, Minister, at paragraph 222 of your statement. If you could look at that for a moment.
Yep.
I believe that you say at paragraph 222, I believe that Victoria's Aboriginal Cultural Heritage Protection and Management System is strong in terms of both Aboriginal rights and regulation of industry behaviour.
Yes.
That's your view?
Yes.
Further, at paragraph 223, you say, I recognise the work of the Aboriginal Heritage Council, including its report, take control of our heritage, and I am committed to continuing to work with the Council and traditional owners on the continued and strengthened protection of Aboriginal cultural heritage that under the AHA as we work towards this goal. So
yep,
that's a commitment that you've made in your statement to
Yes.
continue that work. And at paragraph 224, you also acknowledge that instead of advancing plans for strengthening of cultural heritage, traditional owners' efforts may often be focused on minimising harm because caused by developments and other land uses. And that's an observation you've made from your experience, is it?
Yes, it is.
And then at paragraph 237, you observe that Victoria's Aboriginal Cultural Heritage Protection System and its underpinning legislation is nation leading. It is a model for the rest of the nation, but more needs to be done to improve Aboriginal self-determination. Is there a foundation for that submission?
Yes. My department has recently presented to a federal roundtable on cultural heritage management around, I guess, building the policy and ideas around cultural heritage management at a national level. So that there appears to be no other state that's progressed the legislation and has done it in partnership with traditional owners like Victoria has been able to do. I'm absolutely appalled and dismayed at the responses of some other states like WA and the way that they've walked away from their commitments in this space. And, you know, I look forward to and welcome the opportunity for the federal government to step up in this space.
So I can tell you that in the Department of Premier and Cabinet background paper on Aboriginal cultural heritage, the DPC has informed the Commission that in these terms, recommendations from the Council's taking control of our heritage document were considered and will inform forthcoming amendments to the Act as well as ongoing reform. As of writing of 24 recommendations, 14 may be options for legislative reform and 10 require additional discussions with the Council. Is that your understanding of the position?
Yes, but also within that, we are also seeking advice around amendments to regulations as well.
But there's no timetable for that reform process that you're able to speak to today. Is that correct?
Not that comes to mind, but I'd be happy to come back if there is. Yeah. Come back to the Commission with further information.
By that response, are we to understand that there may be things that are imminent?
In receiving advice like what you've just read out, we consider that advice. We look at what we can legitimately take forward, both through a policy process and then a legislative process. If a legislative process is not required, then we don't usually pursue it because it saves time, and that's been a big issue we've talked about today. So,
of course, you wouldn't take forward legislation if it's unnecessary. One moment, Commissioners. One moment, Commissioners. They are my questions for this witness. Do the Commissioners have any questions?
Yes, I just, for fear of overburdening you, Minister, after a long day, but I think the hearing as well as your statement has shone the light on some quite serious shortcomings, and you have very frankly acknowledged that they exist. And you have said, as I understand you, that radical change is needed in order to address many of these shortcomings and expressed the confidence that the way many of them will be is through treaty. And I wonder if you can just explain what gives you that confidence. Is it a question of the process, or is it something else like the people, or because unfortunately, against the background of the shortcomings, I fear that some will look upon treaty as potentially yet another way of delay. There is such a sensitivity in the Indigenous community that every time we nearly get to the finishing post, there's another committee, another framework, another policy. And is there some reassurance you can give that the treaty process is different? Is this radical change that you referred to?
I guess going off the examples of how I've seen it successfully work with other countries, and Australia being the only westernised, colonised country to not have a treaty with its First Peoples, shows that we've got so much to make up for, that we really cannot waste time, and we've heard that today about time being wasted. We cannot waste time not being at the table and trying to sort this out. And when I had those conversations with First Nations, with First Peoples and communities on country in the main, back when I started in this role, and asking what is the solution, and hearing that truth-telling is a really important part of that solution, but an outcome like treaty is the most important solution. You know, and I got asked about any kind of changes I would make in the time, if I could go back in time, and saying I wish we had done this sooner. In a way, I could contradict myself and say that it's taken us 8 years to get here because we've had to build a new pathway and a new piece, multiple pieces of legislation to be able to even get to this point in time. I don't think it will take as long for other states to do it, because we already have other states looking at the model that we've built here. And I feel that whilst there's a big level of frustration that we've heard about today, I do feel that we've built a new pathway of trust and a new bond. And part of that is the establishment and election of First Peoples Assembly, having 2 iterations of that now, seeing more and more First Peoples actually voting and participating in that process, shows that there is confidence there. And more people in government, on the government side, becoming engaged and educated and wanting to be part of the process, shows me that we are on the right path. And yes, this can deliver the outcomes that we're looking for.
Thank you.
There you go. Minister, I presented at a statewide treaty conference a couple of weeks ago on Wadawurrung country. And I asked this question yesterday of the co-chairs. UDOC has a mandate and a large, significant terms of reference covering a very broad range of really important matters to our people. But we do have a time frame.
Yes.
Keyword time again. What, as the government, having internal thoughts and conversations about what ongoing truth-telling may or may not look like?
Yes, we have. And have we reached a final position on that? No. I think there are a number of avenues that we could look at around ongoing truth-telling, and I do believe it's a really important part of the process. I mean, ideally, it would be great to have completed all of the truth-telling before we get to the table of negotiation. But as we've said, time cannot wait. And I think they can concurrently continue to run together, because I think the public record, particularly at a local geographical level with a traditional owner group, is really important, that we have an opportunity to have that on the historical record. I know that all of your staff and yourselves as commissioners have done an amazing job in the work that you've done in trying to capture that history so far. But there is so much I acknowledge that needs to be done beyond these hearings. Yeah.
And a follow-up question, and I asked this yesterday as well, but what does a shared future look like?
Shared future. Well, it means handing over and sharing power and sharing resources, which comes in the form of many forms. And I'm not going to predetermine some of the claims that the First Peoples are going to Assembly are going to put on the table,
Yep.
but that, in a nutshell, is what it is for me.
Thanks, Minister.
Can I just ask briefly one more? I think Maggie's got anything. So the broader public, there's a lot of work to be done with the broader public. Whose responsibility is it to bring the broader public along?
I think definitely myself as a minister, but also all of our government, it has a role in doing that. But, you know, we're going to be partnering with a whole range of other community leaders, from multicultural leaders through to local government leaders, through to the federal government, to help us advocate and get the word out around what treaty means and how it can benefit Victorians.
Also in that context, understanding the history and linking it. I know we're doing, you know, that public record part, but then we finish. So whose role is it then to make sure that the stories aren't lost, that people can understand what happened in the past and why we need to have a treaty?
I think, to be honest, it's the whole of society's role to make sure that that happens. This is the resource that we've been able to give at this stage, but that doesn't mean that there won't be further resources around truth-telling, and it doesn't mean that the education stops. It needs to continue. There will be a role for government to embed that further, but I think it's also upon our current community leaders to all over Victoria to embrace the findings of this commission.
One more. Promise it's the last one. I know it's been a long day. I've asked this previously, but is there anything further? You know, we've talked about a lot of pain, suffering and trauma, but also the resistance of our people through the start of these land injustice hearings and the significant gains that, you know, hard fought, but significant gains that they've been able to achieve. But is there anything further that you would like to say to our people who are listening in? And we've touched on we talked about massacres and early colonisation impacts through to the deprivation and the lack of economic prosperity that we're able to generate from traditional owner settlement agreements and so forth. Is there anything further that you'd like to say to our people listening in here today?
I'd like to acknowledge the hurt and the pain that First Peoples felt post the referendum result last year, and to remind them that there certainly were still millions of Victorians that voted yes for that process. Now, our process is not the same. It's never been the same. We've taken the pathway of walking together and making sure that we can back up our commitments with legislation. But we want to take all people with us on this journey, because that's what helps embed power and respect. And empowerment is what I meant, empowerment and respect. And to really fight racism, we actually need to take everyone on the journey with us in regards to this. So for those who are still nervous about the journey ahead, I say don't be. I think that the investment that we've made in this Truth-Telling Commission and the commitments that we've made in stepping up a First Peoples Assembly show that this government is real and serious about getting good outcomes from a treaty process.
Commissioners, I might just tender documents relating to today's evidence. You'll recall I tendered the witness statement of the Minister dated the 18th of March 2024. We also tender the article Europe hits back after government rejects crucial Indigenous reforms authored by Kieran Rooney and Rachel Eddy, dated the 3rd of April 2024. and a letter from Minister Hutchins to Mr. Paul Patton dated 5th of December 2023, and finally a letter from Minister Hutchins to the Honourable Matt Keogh MP dated the 7th of March 2024. Commissioners, that evidence from the Minister concludes our witnesses for today. And the Commission will hear from further witnesses on Monday at 10 a.m. Tomorrow is a non-sitting day, and that concludes the proceedings for today.
Thank you, Council, and thank you, Minister. Thank you.